This is Randy Alford with the California Air Resources Board. We're here to go over the course before us. It's course 525. This is a compliance overview. Hopefully you're all here for that purpose. I've got a list of the regulations that we're going to cover in today's class. And we need to go through a couple of administrative things before I can go in. But first off, I want to introduce the co-instructor today, Katie King. Katie, do you want to say hi?
Yeah, good afternoon, everyone.
So the way this is going to work is I'm going to be presenting first, and then when we get down to the off-road regulation, Katie's going to come in and regale you with her information about that, and then I'll cover up the last part of this class on the portable equipment registration program. But we do have a couple more things I want to talk about before I actually get into the information. First and foremost, I want to let you know that this is being recorded. We record all of our webinars, as a matter of fact, and after the presentation is over, about 2 hours later, I will have a link that I can send out to anybody who wants a recorded version of this presentation. It is something that we hold on to for a while, so if later on you decide that you want to look through this again, please let either Katie or I know, and we will make sure we give you that link. It's not something that you can get directly unless you contact one of us, because it's stored at the GoToWebinar site. So one of the other things you need to be aware of is there are a couple of handouts associated with this class. In the dialog box on the right-hand side of your screen, the GoToWebinar dialog box, you should see several different things. Down toward the bottom, you should see a thing that says handouts. And in this case, it's handouts 2 of 5. We have 2 separate handouts for today's class. The first one is the compliance overview handout for the main portion of the course. The second thing is a relatively new addition. You guys ought to feel privileged, because I'm going to be going through the basics on a new regulation that was just passed by our board last month, and that's the Advanced Clean Trucks regulation. I'm not going to go deep dive into that program, but I will cover some of the basics of it. So I created a separate handout just for that. So I would encourage you, if you want to keep copies of those, to download those both sometime during the presentation. I say that during because once the presentation is over, you won't have access to those. Now, Katie and I can send them to you later on, but I would prefer, if you wanted to have them, that you downloaded them while we're going at it. The other thing that you need to be aware of is during this presentation, you are all on mute. Right now, I'm the only one whose mic is actually active because I'm the one who's speaking. When Katie's ready to do her thing, her mic will be active and she'll speak, and I'll go on a mute. So if you have questions, you're not going to be able to ask them directly. There are 2 things that you can do. One is to raise your hand, and Katie or I can take a look at that. But the better thing to do is to actually type your question into the questions dialog box, also on the right-hand side of your screen. That is being manned by Katie right now. In fact, if you have a question related to anything that we're going to be covering in this class, type it in there, and she has the option of doing one of several things. She'll either answer the question to you directly, or she'll answer it to the entire audience directly. Or if it's an important enough question or one that's being asked pretty regularly, she's going to stop me during the presentation and repeat the question so that I can answer it on air, basically. So, but again, during the presentation, make sure that's where you type your questions. This class is, I like to call it a little bit high level, because we have so many different regulations that I'm going to be speaking to. I want to make sure you understand that we don't go deep dive into any one of the regulations. We cover the basics that we believe are necessary for you to understand what the requirements are. But overall, there are I wouldn't say better, there are more in-depth classes associated with each of these regulations. So be aware that there's more information out there that we can present to you in this short period of time. And that's probably a question that people have on their minds. What is the period of time we're going to be doing this? I would suspect that we'll be done somewhere around 3 o'clock to 3:30. That is the normal time frame for covering this information. All right, so it looks like we've got about 69, or what is that, 60 people here this afternoon so far. Hopefully we get a few more, but let's get to the information. First and foremost, I need to give you a little regulatory background This is something that's required for us to do for all of our classes. I need to tell you why we're doing what we're doing and how some of these regulations came about. So first thing that I need to make sure you're aware of is why we have diesel regulations. And the main reason we do this is because of the particulates that are coming from the diesel engines. There's actually two different pollutants that diesel engines produce that we're really keyed on. One is diesel particulate matter and the other is oxides of nitrogen. I'm not going to be speaking to the oxides of nitrogen particularly, but I will talk about the dust, because the dust coming from a diesel engine has two issues that we really care about. Number one is its size. The size of this stuff is incredibly small. The slide you see before you actually demonstrates the size of the two types of particulates that are coming from a diesel engine, PM10 and PM2.5. And it's referencing them in relation to something we all have seen before, and that's human hair. You can see that they're incredibly small. And the problem with this is that when they get to be that size, they actually are capable of getting into our blood system or deep, deep down into our lungs where we cannot expel them. That's problem number one. Problem number two is that diesel particulate matter has been demonstrated multiple times by many different universities and private investigators to have incredibly toxic properties. It's not a single chemical. It's made up of hundreds of other chemicals that are all part of the combustion process. So when you breathe these particles in, not only do they get into the deepest part of your lungs, but you're getting very toxic material into the deepest part of your lungs. So that's the main reason why diesel particulate matter is the issue when we talk about diesel engines. We also have to deal with what reality is here in California. Now, the data that I'm going to show you on this slide and the next slide are charts that were put together by the American Lung Association using information that was gathered from air monitoring sites that are placed all over the state of California, as well as all throughout this country. Every major population center in the United States has multiple air monitoring sites that are basically trying to determine what the range of pollutants are that are in that area. And this data is being collected 24 hours a day, 365 days a year. It's collected, it's tabulated, it's put into databases, and at some point it has to make it to the federal government because EPA requires that we send them this information. Well, that information, because it's health related, is actually public. So anybody, any organization or any individual person really could go in there and take a look at this data. Now, the American Lung Association, what they do is they take a look at the data collected from these air monitoring sites for all pollutants, and they look at the top 300 metropolitan areas based on population in the United States. And then they look at how many times each of those areas exceeded a level of pollutant that we consider to be dangerous. The more often a site exceeds these levels, the higher up on this list they go. So what you're really looking at here for particulate matter and ozone are the top 10 worst places in the country to live for high levels of these substances. Now, I'm going to repeat that because it bears repeating. The top 10 worst places in the country. One thing you should see immediately is that there are more of these locations in California than anywhere else. We have 6 of the top 10 worst places in the country for particulate matter, and we have the top 6 worst places and 7 of the top 10 worst places for ozone. You could say we're winning this contest, and this is not a contest that we really want to win. If you really want to know what drives people in my agency to come to work and try and do a good job, it's looking at data like this over and over and over again. And I'd have to say, I would really hate to see the numbers coming from air monitoring sites in the Northern California area right now for particulate matter, because I know where I live and where Katie lives, we're being fumigated by some of the smoke coming from the fires now. Anyway, that's another story. Let me show you one more slide about this and give you a little bit more information. And that's related to something called short-term particulate pollution. This is highs measured over just a 24-hour period. And as you can see, when we measure particulate matter or any pollutants really, we look at them in 2 different ways. We look at long-term pollution issues as well as the short-term one, because they both have significant impacts. Short-term can also be called acute, and that's what we're looking at right now. It's dangerous when it gets to super high levels. I'm positive we're experiencing acute levels of particulate matter pollution right now, and the Sacramento area will probably jump up this list just because of this week. But what you're looking at here are the top 10 of the top 20 worst places for short-term particulate matter pollution. This was also from the 2019 data. So not only are we winning the long-term contest, but we're gangbusters winning the short-term pollution contest. All right, I'll step off my soapbox now and get into the material so you all can get the material or information that you're looking for. Today, we're going to be talking about several regulations. I've highlighted a few of them on this slide, but my point in showing this slide today is to help you understand that this has been a process ever since the Air Resources Board designated diesel particulate matter as something called a toxic airborne contaminant. We have been writing regulations and enforcing regulations on diesel engines. And each of those regulations has its own process and was promulgated at a different time. So you can see kind of the timeline here. These are not all of the regulations, just some of the regulations that have been passed, but this does happen to be a majority. One of these is actually going to fall off, and that's the off-road agricultural regulation. I like to point this out because many people believe that ARB doesn't change the way they do things based on public perception and public input. And I want to let you know that we did change the way we were doing this when it came to the ag vehicles. There was a point after the truck and bus rule was promulgated that we were going to also regulate off-road ag vehicles. That meant the tractors that farmers used to plow their fields and haul hay and all that good stuff. Because of input from not just the farmers, but from a variety of sources, and because of the issues that we were having in implementing the truck and bus regulation, we decided to take a different approach with the off-road ag. It's not that we don't need some reductions in that area, it's that we decided to not go command and control, and that is to say we decided not to require them to change their equipment out, but rather we started to build incentive programs like one called the Farmer Program, where we actually provide funds to get farmers to voluntarily take old equipment out and install newer equipment. That's where we're going with off-road ag. So it is a good thing that we're using both methods of trying to get this stuff cleaner. Let's get to the first rule of the day, though, and this is the truck and bus regulation. And this is what I like to call an omnibus regulation, because it was a rule that came about well after many other rules that dealt with on-road type of vehicles. And the basic idea for this rule was to capture all those vehicles that had not previously been regulated. So it covered everything that didn't already have a rule covering it. That's again why I call it an omnibus regulation. It does cover any private or federal fleet that is in California running any form of diesel fuel, and it's based on what the gross vehicle weight rating is of that particular vehicle. So if you have a commercial diesel truck operating on California roads and it has a gross weight more than 14,000 pounds, there is a high likelihood it falls under this regulation. This rule does include public and private school buses, although they have very different requirements in many cases than the other vehicles falling under this rule. And it covers two-engine street sweepers. One thing I want to make sure that everybody in this audience knows, especially those people that are from public agencies, is that even though they may be defined the same way as the vehicle I'm talking about right now, any vehicle that is owned or operated by a public agency or a public or private utility does not fall under this regulation. It would fall under something called the Public Agency Utility Regulation. And that is to say your white fleet vehicles. So I get a lot of people who get confused with the idea that they work for public agencies and they listen to me talking or Katie talking about this on-road truck and bus thing, and they think that that's their rule when it's not. If you belong to a public agency, there are some rules we're going to talk about that do cover your fleets, but I want you to understand that any of your on-road stuff, I can give you the information about those if you like, but just contact me via email and I'll be happy to do that. We also have another course, 2 extra courses actually, one that focuses on schools, that's MS 523, and then we have one that focuses on public agencies, and that's MS 522. So if you get our bulletins, look for those courses to get an explanation of what regulations actually cover your fleets. Now, who are we going to hold responsible for the compliance of the vehicles that I just described? Well, it's going to be obvious that if you own one of these vehicles, you are going to be responsible for it. If you lease or rent a vehicle, it's possible you could be responsible. It all depends on how the wording is done in your contract. You'd have to find out whether or not there's any clause in your contract that actually says you're responsible. If there isn't, then it's the owner of the vehicle, which would be the company doing the leasing or renting. If you sell a vehicle to anybody if you sell a vehicle that falls under this regulation to anybody that is going to operate it in the state of California, we're not saying that you have to make that vehicle compliant, but there is a requirement that you include language in your sales contract that warns these new owners that there is a regulation. And then there's the California-based brokers and dispatchers part of this regulation. This is something that's, I want to say, relatively new to many of our regulations because it wasn't in some of the early ones. But essentially what it does do is it lays responsibility on those companies that broker the use of vehicles or hire operators and their trucks to do work. It essentially says that if you're going to hire somebody to move material using a vehicle that is falling under this regulation, that you have an obligation to only hire compliant operators with compliant vehicles. That means that you're going to have to take some due diligence to ensure that you're making a check to see that they're compliant. Now, there are many different ways that you can do this check. We have a advisory that is listed right there, or there's an advisory, not that particular one, that will give you an outline of the different methods that our enforcement division will accept for actually meeting the broker dispatcher requirement. Perhaps the most common one is to use something called the Certificate of Reported Compliance, which I should talk about later. That is one that the enforcement division usually will accept as you haven't done your due diligence. But make sure you hire compliant fleets. All right. There are always exclusions to regulations. Many of them are common throughout our regulations. For example, almost all emergency use vehicles are exempt from this rule. Let me go forward. Military tactical vehicles have a general exemption from most of our regulations. Personal use motorhomes are specifically exempt from this rule. Generally speaking, personal use vehicles are not covered by our regulations. We are generally talking about commercial use when we have a rule like this truck and bus regulation. There is one exception to that, and that would be very large personal use pickup trucks. We do have a little bit of an issue with this particular part of the regulation. First of all, it's a weight thing. So if you know anybody that has one of those really souped up, car crusher type trucks that is over 19,500 pounds gross weight and is a diesel truck, then you're going to want to make sure they understand that that truck most likely falls under this regulation, even if it is a personal use pickup truck. The other problem we have with this definition or this particular part of the exemptions is the fact that we use the term pickup truck. Personal use, everybody understands that, but when you deal with the term pickup truck, you should understand that that means that it has a pickup bed, not something other than a pickup bed. This has been confusing to a number of people who have personal use trucks that they have put other types of beds on. I ran into a gentleman up in Redding not that long ago who had a F-450 Ford truck, beautiful vehicle that was not in compliance with this regulation, but he was personal use. And somewhere along the line, he had installed a flatbed with stake sides and a Tommy lift on the back of it. Those are commercial components, and it's no longer a pickup bed. So even though that vehicle would be considered personal use by him, it would fall under this regulation because it has those components that don't make it exempt as a personal use pickup. If you have more questions on that, we'd certainly be willing to talk to you more about that. But let's keep going through the exclusions. Historic vehicles are also considered to be exempt, but in order for that to be true, the vehicle has to actually be registered through DMV as a historic vehicle, like the one pictured there. Those are show vehicles, all nice and chromed up and clean, and they're not used to haul anything because their registration does not allow it. So if you have a vehicle like that, it is exempt by definition. If you have a vehicle that you believe is historic to your particular group or company or organization, but it's not registered as historic, you're going to want to take a step back and double take it, because most likely that vehicle does still have requirements under this regulation. And then we've got vehicles that are subject to other in-use rules. By that, I'm saying one of the reasons that I go over all the rules at the very beginning is because if you look at that list, you'll see lots of vehicles that could be defined as being under the truck and bus rule. But the thing about it is they were covered by another regulation before the truck and bus rule even existed. They don't go out of that other rule and into the truck and bus typically. They would stay in the requirements of that other rule. So for example, we had a rule that covered solid waste collection vehicles, dump trucks. And because all those vehicles were taken care of in the regulatory sense before the truck and bus rule was even created, they are still covered by that rule. They do not come out of that rule and fall under truck and bus. So we typically don't cover things twice. All right, so I was talking about the personal use pickup thing just a few minutes ago, and I want to make sure you know there is a way for anybody that has a vehicle that they believe is exempt from this rule for one reason or another to try and get that thing taken care of and get the exemption listed. And one of the biggest problems that we've had over the last several months and the last 2 years really is the fact that we're working with DMV registration right now to enforce this regulation. So if your vehicle is seen as falling under the truck and bus rule, it is entirely possible that you could be caught up in a scenario where you may not be able to get your vehicle registered because DMV lists it as a vehicle that is non-compliant. And that's where personally used pickup trucks are having problems. So we created a separate, smaller reporting system called the Excluded Diesel Vehicle Reporting System, or EDVR, for anybody that has a vehicle that may fall under an exemption like that. You go in there, you report, you may be asked to submit some photos or other examples that might demonstrate that this is an exempt vehicle, and then we'll put it on the nice list, so to speak, and DMV will not bother you with these regulatory requirements. All right, so that's the preamble to the rule. Let's actually talk about the requirements. Before I can actually get into those, though, we have to do one more breakdown, and that is to separate your class of vehicles, your fleet, into one of two types, because that's what this rule does. It says everything over 14,000 pounds diesel in California is, it's not already covered by a rule, and it doesn't have an exemption, falls into this rule. However, even after you meet those qualifications, we still have to know the weight class of each of the vehicles that falls under the rule, because there are two separate requirements in this rule, and they are based on weight class. We break the vehicles into either what we're calling a light vehicle, which is anything that is 14,001 up to and including 26,000 pounds gross vehicle weight rating, or it's a heavy vehicle, which would be anything over 26,000 pounds. If you want to relate that to commercial class ratings, the light vehicles are the class 4, 5, and 6. The heavy vehicles are the class 7 or 8. Once you have that information, and where do you find that information, by the way? Well, that's what I have this slide for, because the gross vehicle weight rating is something that you typically can find on a door jamb tag that's on the inside driver's side of the vehicle. So the inside driver's door jamb will usually have a tag that is placed there by the manufacturer of the truck, and it will have possibly many different weight classes listed. You might have a rear axle weight, a unladen weight. There's all different kinds of weights that could be on there. But the one that makes a difference for our enforcement people and for this rule is that one that says gross weight. Now, it could say gross weight like this one. It could say GVW. It could say GVWR. Any of those are the number that we're looking for. The second piece of information that we're looking for, because it makes a difference as to what your requirement is the model year of the engine. So I cannot tell you how many times people have told me, I've asked them, okay, they were asking me what the requirement is. And one of my first questions is, how heavy is the vehicle? What's the gross weight? And my next question is, what is the model year of the engine? And they break out and tell me what the model year of their truck is. Oh, I have a 2000 truck. Well, that doesn't tell me the model year of the engine. That tells me when the truck was built. That tells me when it was put together, but it does not give me the model year of the engine. The reason we're focused on the model year of the engine is because federal EPA certifies on-road engines to a model year standard. So when we're looking at the emission rates that are allowed by this rule or required to be met by this rule, we need to know what model year you have to understand how your engine was certified. So that is not going to be in any of your documentation that you get with the vehicle typically. It'll only exist on a tag that is required by federal EPA to be on the engine itself. The tag you can see a picture of right there, this is called an emissions control label, or ECL. It is on the engine, somewhere on the engine. Sometimes they're just in the engine compartment. Lately, I've seen them in special boxes that are on the firewall. And I guess technically that's on the engine, but in any case, most of the ones prior to the ones those are on the engine itself. Now, these tags can be anywhere on the engine. They can be on the engine. They could be made of almost any material you can imagine. I've seen them made out of stamped steel, stamped aluminum. I've seen them made out of stickers, metal stickers. This particular one happens to be a foil sticker that has a plastic coating over the top of it. So there's no requirement that it be made out of anything in particular. What we're looking for is that it has the right information. Oh, and by the way, if you want to know which is the right tag, I don't know if you can really see it on this one. I can barely read it myself. All these tags that I've ever seen have the same phrase on the top of them, and that phrase is important engine information. If you see a tag on your engine that has that three-word phrase, important engine information, then that is the right tag. It will tell you what the model year of that engine is, and that's what we look for. I also want to point out that if you want to know what the single most common citation written by the Air Resources Board Enforcement Division every year, it's for missing or illegible emission control labels. Think about it for a second. If our inspectors are out in the field and they need to know not only what the weight class of your vehicle is, but what the model year of the engine is, they're going to be looking for these two tags. If they cannot find one of these tags, they cannot do their inspection. They're going to write a citation for not being able to do their inspection. And since this is federally required and we're enforcing that, it is literally its own violation. So that is a really common citation. All right, so once we found that information, though, then we have to go to what the actual requirement is for the size of vehicle that you have. So if you have a light vehicle, our inspectors, our office people, anybody involved in this is going to look at this chart. Very simple chart to read. It only has two columns. One is for the model year of the engine, and the other is for the requirement date that that engine has to meet some certain requirement. And the requirement in this case for the light vehicles is that by a specified date, those engines have to meet 2010 model year emission standards. So it's the model year of the engine first, just to find out what year you have to do something. And then that year, that date, whatever that date is when that engine has to meet 2010 model year emission standards. Now, this is confusing for a lot of people because a lot of people don't know what that means, 2010 model year engine. How do you meet 2010 model year engine standards? Well, you have to have a 2010 model year engine. There is no retrofit that you can install on an existing engine to turn it into a 2010 or newer engine. There's no filter you can put on it. There's no nothing that you can put on it. It means a repower of that engine. There's too many different things on those 2010 engines that weren't on engines before for you to have any retrofit that you can install on. So it is what it is on a particular date. And let's take an example. Let's say somebody in the audience has a 2005 model year engine vehicle. If you look at this chart, they fall under the, not the last, but the second to last row. That is the 04 to 06 model year engines. Those vehicles, up until the end of this year, do not have a requirement. They can drive anywhere in the state. They can go as many miles as they want. They don't have to do anything to their vehicle. They don't even have to report that vehicle. But on January 1st of 2021, that vehicle is not legal to drive in its original equipment state. The 05 engine is no longer legal to operate in this weight class in California. It has to meet 2010 emission standards. And again, I just said you can't put anything on it to meet that. It has to be repowered. So the options at that point are not very good. You either have to repower the vehicle with a new engine or a newer engine, or you have to get rid of the vehicle, retire it, or you have to drop it down to low use. I'll talk about low use later, but just so you understand, the low use option is something that a lot of people are using so they can get their DMV registration, but it really doesn't allow for very much operation. Anyway, that's for the light vehicles. That's what it is. When we look at the heavy vehicles, it's the same chart with one additional column, and it says PM filter. So what that really means, or meant, because it's past now, is that the same model year engine thing applies. Ultimately, they all have to meet 2010 emission standards, which is the last column. But in between the time this rule was put in place and the date that they have to meet 2010 emission standards, there was a requirement that each of those vehicles put a retrofit diesel particulate filter on. You can see the dates. If you had that same 2005 model year engine, but it was in the heavy class, that should have had a filter on it by January 1st of 2013. And then January 1st of 2021, even though they installed the filter back in 2013, January 1st of 21, that engine has to meet 2010 emission standards, which means exactly the same thing as I said for the light vehicles. It either has to be retired, repowered, or put into low use. Even with a filter, that is true. As long as your vehicle is in compliance with either of these charts, as I said before, there is no reporting required. The reporting system associated with this regulation was designed to help people go outside this box, so to speak, to do something that doesn't meet these conditions, because we had lots of different options in this regulation. And in fact, we should talk about those. They're called flexibility options. They were options that gave extensions, they gave delays on the general compliance requirements for filtration or 2010 model year engines. You had to be eligible for each provision, and the eligibility depended on a number of things. There were provisions that were flexibility options that allowed small fleets, that would be fleets of 3 or fewer trucks, to take longer as long as they were identified as such and reported as such. There were options in this rule for agricultural trucks. There were options for construction vehicles, lots of different options. Most of those options have gone away at this point because we're almost to the point where this rule is near its sunset provision point, but they still existed, and there are still a number of them that are being used. One of the things that happened back in 2018 and 2019, however, actually it happened in 2014, but it came into play in 2018, is that we were sued by a company called Lawson Trucking in conjunction with CTA back in 2014. They chose 2014 because we had made some modifications to this regulation, which gave extensions to people and more options. And Lawson fought us on that. CTA fought us on that under the reasoning that we had just given extensions to people who had not paid to clean the vehicles up per what the regulation required. And Lawson and CTA had already made those changes, had already paid for filtration systems, had already done what they were supposed to do. And when we gave extensions to people under the 2014 amendments, we actually created an unfair business advantage for the people that got those extensions. And while I actually agree with that line of thought, I also agreed with creating the extensions. So I was kind of in the middle, but it doesn't matter where I was. It matters that they filed this lawsuit, and in 2015, early 2015, we found out that we had lost the case. They actually won the case. Now, what that meant at the time was that we had to do something because they were going to invalidate the regulation entirely. We filed an appeal, and that appeal took us all the way out till April of 2018. In 2018, the administrative law judge that was overseeing the case came back and basically told us that we had lost the case. So there's not going to be any more appeals. There hasn't been any more appeals. And what it really did is it voided all the 2014 amendments. Now, for most people under the rule, that should not have had any tremendous impact, but there were a few small things that happened related to that. The larger impacts were shown under these particular provisions: heavy cranes, low use ag, Knox exempt areas, extended filter use, and low use exemption. So I'll go through each of those. I don't know if anybody in this room has what's called a heavy crane. A heavy crane has to be an on-road crane that's over 54,000 pounds. You have to have a special license to operate it. You have to be a crane operator, certified crane operator, and it's a very particular kind of vehicle. That provision for heavy cranes allowed them to not have to filter. There was a grandfather clause for anyone that did, and it gave them an extension up till 2028 or something like that for converting the engines to 2010 engines. Because it did not exist prior to 2014, when the lawsuit took effect, it was abolished. So all these owners of heavy cranes would have been in a world of hurt because they would have had to go back to the standard set by the original truck and bus rule before those amendments. So what we did was, because there was a lot of people that took advantage of this provision, and it would have meant a tremendous amount of bad deals for a lot of people. What we did is we took the provision out of the truck and bus rule and inserted it into the solid waste collection regulation in its entirety, so that the provision still exists and the vehicles still follow that provision. They just are following the solid waste collection rule, not the truck and bus rule. It's kind of a sleight of hand, but it worked, and anybody that took advantage of this provision falls under that rule. Ag vehicles had a little bit more trouble, and it really only affected a 1 year, really, because what it did is if you were in the ag mileage or ag vehicle mileage extension, you were getting up to 15,000 miles per year all the way until 2020 under this provision. And what the lawsuit did was it took away 5,000 miles in 2019. Because the 10,000 mile limitation was going to start in 2020 in any case. There was more of an impact for anybody that was able to get into the provision under being a cattle truck, but that's no longer considered an ag vehicle. So this is what it is. Now, the ag vehicles are still following the same provision as long as they were registered and labeled properly. They have 10,000 miles per year each year until January 1st of 2023. And then at that point, they can drop down to low use and the provision goes away, but it is what it is. Low NOx is an interesting one. Well, this is one that's going to exist for a long time, actually. It doesn't go away at any point. Essentially, what the provision is about is if you look at this map and you see all the dark green shaded areas on the map, those are areas that were identified at the beginning when we were writing this regulation. They were identified as areas that the ambient air quality standards for NOx were being met on a federal level. So because those areas were meeting the federal NOx emissions or ambient air quality standards, we didn't need any improvement in that area in those parts of the state. And that's what the second half of the rule actually does. The 2010 engine is an engine designed to reduce NOx. The 2007 engine reduced particulate matter, and the 2010 engine, the additional reduction would be in NOx. So really what this provision does is it allows people to operate with the filter and never having to ever update to 2010 engines. If you have a vehicle that operates in any one of these dark green areas and stays in those dark green areas, then that is still an option for you. You need to filter the truck, but once you filter the truck, as long as you're reported properly, you can still take advantage of the fact that you don't have to update it to a 2010 or newer model year engine. The reason I show the map the way it is, though, is because the lawsuit actually took some of the areas away. There are some light shaded areas shown. Those were added in 2014, and the lawsuit basically took them away. So we had some people that kind of got messed up when that happened. All right, extended use of PM filters. What happened here really is that we had a clause in the regulation prior to 2014 that if any owner of a fleet was able to get all of their vehicles filtered prior to 2014, prior to January 1st of 2014, that there would be no replacement of any of their vehicles required until January 1st of 2023. And that might have been a tremendous boon depending on the fleet, how the fleet was comprised. So that provision still exists, but in 2014, we actually modified it to say it didn't have to be your entire fleet, just one vehicle would qualify. When the lawsuit happened, that went away. So it's back to being the entire fleet. This almost solely affects single owner operators. And we have gone through a lot of trouble in our reporting system to identify those people that actually meet the conditions. But if you believe that you should qualify for this extension, you still have a couple of years that you might be able to get out of it. It's just difficult to get into at this point because you have to be the one who owned the vehicle prior to 2014. Excuse me, you have to be the one that put the filter on, and it has to have been your entire fleet that was filtered in order to qualify for this. We do have a mechanism and a part of the reporting system that you can go through to try and get this if you do qualify, but it does require some demonstration of proof. All right, let's talk low use, because low use is something that is being used quite a bit right now, and it has been for some time. Low use provision allows you to operate a vehicle without putting filtration systems on or without updating them to 2010 engines at any point, as long as you stay under a mileage limitation that's listed in the regulation. Now in 2014, we added a secondary exemption for any vehicle that could stay under 5,000 miles total, but the lawsuit got rid of that in 2019 and it was gone in 2020, even if the lawsuit hadn't happened. So the low use provision right now essentially says that any vehicle you can keep under 1,000 miles per year in California and under 100 hours of stationary operation in California can be exempt from all the requirements of this rule. The only requirements that you would have are to report the vehicle properly every year, tell us how many miles you went, and keep it under 1,000 miles in California. If you drive it outside the state, those miles don't count. If you use it in a stationary manner outside the state, those hours don't count. Also, in relation to the fires that we're experiencing here in California, I want to say something else about this provision, is that it also exempts any emergency use. So I said earlier that emergency vehicles are exempt, and that's still true, but it's also true that if you have a vehicle that is not an emergency vehicle, but it is used for emergency purposes, and you're under a government contract for that use, your use during emergencies is exempt from the truck and bus regulations. So for example, right now today, we've got fires down in the Central Coast area, the Monterey, Santa Cruz area. We've got fires in the Vacaville, Fairfield area, Lake Berryessa. If there are water tender trucks that are owned and operated by commercial owners, but are being hired by CAL FIRE to water tend those areas and help with the fire, right now, during this period of time, the use of those trucks is completely exempt. So all the miles to the events, all the miles and hours at the event, and all the miles and hours back home from the events are all considered exempt. You just have to track it and you have to report it. So if you went 10,000 miles in a year, which is obviously more than the limit allows, but 9,500 of those miles were done in service of a CAL FIRE contract for one of the fires we're talking about right now, then you would still be exempt under this provision. Just need to make sure it gets reported properly and that you have the right records. Anyway, that's the low use exemption. I keep mentioning the term reporting because this rule does have a reporting system associated with it. It's called TRUCRS, TRUCRS. There's the expanded acronym right there. But what this is a reporting system that is online. It's used to report vehicles that are following flexibilities. If you wanted to get a certificate of reported compliance, you have to use this system to get it. And we have, let me see if I've got an example. Yeah, there's a link to get there on our Truck Stop webpage. You can see right here, this is the Truck Stop start page. up at the top right-hand corner of this, it says TRUCRS, and it's highlighted in yellow, or that is a link to take you to the reporting system, which will take you here. This is the entry portal to the TRUCRS reporting system. This is where you can create an account or you can log into your existing account. There are also lots of resources that tell you what to report, how to report, non-compliant fleets, all that good stuff. And there's even a way, if you've forgotten your username and password, to try and recover those without having to send an email or call anybody, all right? Ultimately, one of the things that most people want to get out of the system is this certificate that you see an example of on the screen. This is an example of a certificate of reported compliance. Now, it is only available to those owners and operators of trucks and fleets that are reported in the TRUCRS reporting system, that their fleets are, as they are reported, are compliant with the rule, and that have printed their certificate out for the year. That last one is a legal thing. Basically, you could be compliant with this rule, you can have all your vehicles reported, but there is no access to the certificate until you sign off on a legal disclaimer saying that the information you've put in our system is true. Once you've signed off on that disclosure, the certificate is available for you to print off as many times as you want. This is also what I was talking about with brokers and dispatchers. If you're hiring somebody to do work for you and they have a truck that falls under this rule, one of the things you can do is ask them for a copy of the certificate. That would be your due diligence in most cases. The enforcement division has been accepting that as due diligence. So it is something that is widely used for that purpose. All right, that's the truck and bus rule. Let's talk about a couple of other programs that are associated with on-road trucks. The first is one called SB1, or Senate Bill number 1. You probably don't know it by that name. In fact, you probably don't know it by its full name, which is the Road Repair and Accountability Act of 2017. This was a law that was signed into place by Governor Brown when he was still the governor. And you may know it more as the gas tax, because that's what this Senate bill did. It provided a gas tax to provide for road construction. But it also had another part, and that was that it brought the truck and bus regulation and DMV registration together as far as being compliant with the truck and bus being a requirement to get your registration. This is something that started as of 2020, January 1st, 2020. It actually started before that, but that's when it really came into effect. And what it really says is that if you have a vehicle that falls under the truck and bus rule, beginning in 2020, phasing in all the way through January 1st of 2023, you need to demonstrate compliance with the truck and bus rule before DMV will let you get registered. And that means that ultimately you're going to have a 2010 or newer model year engine to be registered for operation in the state of California. That's why it says 2011 vehicle. 2011, the model year of the engines are almost always 1 year behind. So a 2011 vehicle would be the first year where it would most certainly have a 2010 engine. You could have some 2010 vehicles with 2010 engines, but most of them would probably have a 2009 engine. In any case, if you have a newer vehicle, you should see no issue with registration. It's just those older vehicles that are going to have to demonstrate compliance. And again, we talked about the EDVR system earlier, the excluded diesel vehicle reporting system, and the personal use pickup truck issue. That is tied to DMV as well. This all is tied to DMV. We send them reports on a regular basis. We have access to look at the registration. They put holds on vehicles, and then those holds have to be cleared on our side of things before somebody can get their vehicle registered. It's been operating fairly smoothly. There have been a few hiccups, quite a number of headaches, but for the most part, we are in a place right now where most anybody can either get their registration because they're already legal, or they're having to do something to bring their vehicle into compliance, which was the intention in any case. But that's SB1. Here's some contact information. If you need to call and ask questions, we've got a diesel hotline in number as well as an email. And these young people will be able to either answer your questions directly, or they can send you or direct you to someone who should be able to help you if they cannot. We also have some web pages. I showed you the truck stop. That's the main one that I'd send you to. But if you want to know just about the truck and bus regulation, then this is the website to find out information just about this rule. All right, let's talk about PSIP, or Periodic Smoke Inspection Program. This is, although some people think it's new, this is not new. This rule is perhaps the oldest diesel regulation that ARB has, diesel on-road regulation. This was put in place back in 1998. And here's what this is. So we have rules like the truck and bus, which essentially tell you that based on the age of your engine, you have to do certain things. But those are static rules. Once you do whatever that certain thing is, you're in compliance with that rule, and the rule does never ever check you again to see if your emissions, your in-use emissions, are still being low enough to be compliant, because we don't have a smog check for those on-road engines. That's kind of false, because this is what's called an in-use regulation. This is a requirement to keep your vehicle in good mechanical shape so that the emissions from it are minimized. The Periodic Smoke Inspection Program is one that requires all owners of certain fleets to annually do some type of inspection of their vehicles so that we can have some proof that the vehicle is being maintained properly. The reason I'm talking about it here, I know I told you it was an old rule, like 1998, but the reason I'm talking about it here is because there were some modifications that were done back in 2017 and 2018 and became effective in 2019. First, let's talk about the program. So this particular program, it requires a test that goes by a lot of different names. It's been called the Snap Acceleration Test, the Snap Idle Test, the Periodic Smoke Inspection Program, the Heavy Duty Vehicle Inspection Program. It's also been called the Smoke Test or the Puff Test. Lots of different names. They're all the same test. It's really what's called an opacity test, which means we have a meter that we put in the smokestack of your truck, and then we have you put it in park or neutral, and we have you gun the engine 3 times while we take a measurement of how much smoke is coming out of the stack. That's why it's an in-use smog inspection, because we're measuring what it's actually putting out. Now, the PSIP requirement, well, first of all, the HDVIP, the Heavy Duty Vehicle Inspection Program, that is what our inspectors, when they conduct this same test, that program is called HDVIP. So our inspectors out in the field during the week, during the day, they're conducting this test thousands of times per year. And when they do again, it's called the HDVIP. The requirement for you, a truck owner, to do this to your own vehicles comes into play when you meet certain conditions. First of all, if you have 2 or more California-based on-road diesel vehicles that have gross weights of more than 6,000 pounds, and the engine model year is older than 4 years, you're required to conduct this SNAP test, this opacity test, every calendar year. Okay, again, let's repeat this again. You have to have 2 or more California-based diesel on-road trucks or vehicles. They have to be over 6,000 pounds, and the engine model year has to be older than 4 years. If that's you, then you have a requirement to do this test on each of the vehicles that meets that requirement. Let's take a couple of examples here. So let's say I'm a fleet owner and I just have 1 truck. I'm an owner operator. Well, I don't meet the first condition. I don't have 2 or more. So I do not have a PSIP requirement. Well, let's say I have 2 vehicles. One of them is that 2005 I was talking about earlier, and another is a brand new 2020 vehicle. Okay, so I have 2 or more. They're both probably over 6,000 pounds. They're diesel. They're based in California, so I'm part of this test. Well, I only have 1 where the engine is older than 4 years. The other one, I said it was a 2020, which means it probably has a 2019 engine. So that's not over 4 years old. I don't have to test my 2019 engine. I have to test the 2005 engine. The 2019 engine would not have to be tested, so let's figure this out. 2019 is year number 1, 2020 is year number 2, 2021 is year number 3, 2022 is year number 4. So starting in 2022, I would have to test that other vehicle, right? Because as soon as it gets to that 4th year, it's considered older than that 4 years. Anyway, the reason I'm talking about this whole test and trying to bring it to your attention is because of the requirements that were changed in the rule back in 2017 and 2018, and again became effective in 2019. So this rule, the opacity levels that were allowed originally are pretty high. The old levels are 40% and 55%, depending on the model year of the engine. The older engines were allowed more opacity. Those opacity limits have been lowered because of the advent of filtration systems. So the filtration systems made the opacity limits obsolete. So we needed to lower those, but we also in the process decided that we were going to include additional training requirements for some of the people conducting this test. And we also included a program for a voluntary submission of some data in lieu of doing this test. And there's a proposed, several proposals that I'll talk about. One of them is doing this test upon the sale of a vehicle. Let's talk about the requirements first. So,
Randy, real quick.
Sure.
So we have a question, and they were wondering if the name in the TRUCRS account has to be the same as the DMV registration.
The company name?
I think I would assume it's the owner name.
That's a really good question. It would cause confusion if it wasn't. I can think of some circumstances where the name would not be the same. Let's say it's a leasehold or something like that, where the person driving the vehicle may not have the same name on it. It's to a leasing company, where it wouldn't show up the same. But it does cause confusion if it's not the same. I'm not going to say it has to be the same.
Yeah, I don't think it's something that would get you automatically flagged, but if you had an issue and you were trying to go through TRUCRS to solve the issue, then it might lead them to ask more questions verifying ownership before they're able to help you.
Correct. Yeah, so that's good information. Was that it?
Yep, that's it.
All right, so let's finish talking about the opacity levels. I told you the old opacity levels were 40 and 55%, but now the current opacity limit for any vehicle that's equipped with a diesel particulate filter, that's what DPF stands for, is no more than 5% opacity. So substantial drop. I will also tell you that if you're doing this test or having this test performed on your vehicle and you get close to 5%, there is something wrong with the filter on that truck. These diesel particulate filters work very well. And if you get anything more than 2 to 3% opacity, there's probably a crack in the filter or there's something going on, because they remove 99.9% of the soot coming from the diesel engine. And most usually during the opacity test, they will show a 0 or close to a 0 as far as the level that's being measured. Anyway, that's the new limit. There are additional limits for those vehicles who do not have filtration systems. Those would be your low-use vehicles, low-use ag, anything that doesn't have the requirement to have a filter yet. But the opacity levels are still lower, and it's dependent upon the model year of the engines. There are some bigger vehicles or vehicles that fall under other rules that might also have different opacity levels, so those are listed there. But one thing I probably should have said is, hopefully some of you in the audience noticed that I did not have an exemptions slide. That's because this rule doesn't exempt anything. So all those exemptions I had for truck and bus, the emergency vehicles, the ag vehicles, military, none of those things are exempt. Any vehicle that meets the conditions that I just went over, again, 2 on-road diesel California-based trucks over 6,000 pounds, any fleet that meets that is required to do these tests, even if they have exemptions from other regulations. All right. Now for training, when you conduct this test, there's actually 2 different ways that this can happen. You can contract someone to do the test for you. There are hundreds, maybe thousands of people in the state of California that have gone through a training program to be certified to conduct this test, and they charge people to do this test. Some of them will travel to your location. Some of them you have to go to a dealership. In fact, every dealership that I've ever dealt with has somebody there that will conduct this test if you need it done there. They will charge you a rate to do that, and they have to be certified. Now, the certification is done through a community college program that we have here in California called the California Council on Diesel Education and Technology, or CCDET. Short name is CDET, we call it CDET. They have a one-day class that you can go to. Right now it's online, I believe, that you can take the certification, be trained on how to conduct the test, and they will certify you for 4 years. So if I were hiring somebody to do this test for me, I'd do a couple different things. Number one, I would ask them for a copy of their certificate, and I would keep that. Number two, I would look at the certificate. Maybe I'd do this first, but I'd look at their certificate and make sure it wasn't more than 4 years old. Because if it's past 4 years old and that person does the tests, they are not valid, even if they're done correctly otherwise. All right, so that's possibility number one. Possibility number two is that either you're doing the test on your own vehicles, or you have somebody who works for you who tests your particular fleet. Prior to the changes that we're talking about here, those type of testing people did not have to have any training whatsoever to conduct this test. After the changes, they do have a training requirement. It's not that complicated though. We have an online training course. You can see the number there. It's MS529. You can take it online. It's a module driven, takes about an hour and a half. You have to look at some videos and listen to some talking, answer some questions, and as long as you get enough questions correct, you will pass the module and you will be given a certificate as well as a tester number. That tester number has to be entered into the device that's conducting the test. Otherwise, again, it's not a valid test. Let's talk about the testing device for just a second, because there have been some issues with those. The testing devices, there's multiple manufacturers that make these things and sell them. They range in price from, I don't know, maybe $1,500 to $2,000 to up over $7,000 or $8,000. And they have software built into them that's made by the manufacturer to get to these numbers we're talking about. Well, when we made these changes, some of the manufacturers got right on it. They changed their programming and their units. They updated all the units that they had out, and those units are doing just fantastic. Other manufacturers either haven't or are in the process still of updating their software to meet the new opacity levels. They can still conduct the test legally, but they'll give you a pass if you go over 5% because their cut points aren't set properly inside the program. So I'd be a little leery about a test that comes back that says you passed, but the opacity is over 5%. If one of our officers sees that, or if one of our auditors sees that, it's not a passing test, even if the machine says it's passed, because the software wasn't updated properly. So be aware of that and make sure you look at that test strip. Some other current requirements that did not change from the previous version is the record retention. The records have always been required to be kept for 2 years, so you have to have 2 years worth of records, and there is no reporting system for those that you keep. The thing we want you to do is to submit them when we ask for them. And when would we ask for those? Well, if we're auditing your fleet, we're going to ask for them. Why would we audit your fleet? We do random audits periodically, although that hasn't happened that much in the last few years. But one thing that almost always happens is that if you happen to get a citation for a vehicle in your fleet, in clearing the citation, we usually will audit the rest of your fleet. And we will ask for this information if you haven't. So you could have another citation if you didn't keep track of this material. All right, so the other option that I said was added back in when this rule was changed was for the newer trucks. So any truck that has a 2013 model year or newer engine is built with new technology that wasn't in the heavy duty diesel vehicle category prior to this. The 2013 model year engines and newer come with something called onboard diagnostics, or OBD. The onboard diagnostics is essentially the same thing you have in your regular vehicles now, and you've had it since 07, 08, actually earlier than that. 1998, 1997, I'm sorry. But it's OBD, onboard diagnostics. It's a little computer chip that basically controls the engine, but it also monitors everything that's happening. Those vehicles that have this have a little, what's called a dongle underneath the steering column that you can connect to and download information from the computer system. It is possible to take a little device that is designed for this, to download a file from that OBD system and submit it to the reporting system that is shown there on that link. If you are able to do this and the right information comes across, then you do not have to conduct the opacity test. It's one or the other. It's only useful on the newer trucks though, but it is an option. Now for future heavy duty inspection programs, currently our office is working with the Bureau of Automotive Repair. We're putting together a true I&M program, which would mean heavy duty diesel vehicles going through a similar type of dynamometer test that the gasoline and lighter diesel vehicles are required to go through, which provides road condition testing and emissions testing. That is something that's probably going to come about some point later this decade, probably in the 2023 timeframe. At least that's the goal. We're working on it right now. So if you have any ideas about how that program should be, if you're in the industry and you want to participate in that process, we're having public hearings on a regular basis about this. Okay. Here's the new stuff. And you'll have to give me a little bit of a pass because it's new to me as well. I understand this program fairly well, but this is the first time that I'm actually presenting it in a format like this. But this is the latest, greatest regulation that ARB has passed dealing with on-road trucks. It's a set of regulations that are actually proposed. We've got the Advanced Clean Trucks rule, which I'll be talking about here, but that's just the first of three. We have a low NOx omnibus rule that is going to be coming out sometime next year or the year after, and then a zero emission fleet rule that's also going to come out after that. These three rules together are going to provide a pathway for the California to be carbon neutral by somewhere in the 2045 timeframe, and to lower the air pollution, ambient air pollution in all areas of the state significantly. These regulations drive fleets to go electric. The Advanced Clean Truck portion, which was the one that was just passed, has two major components. And the first is just a requirement that manufacturers sell a percentage of heavy heavy zero emission vehicles in place of the diesel vehicles. So we set a percentage of sales, and the manufacturers are supposed to meet that by selling ZEVs over a period of time, and that percentage goes up over time. The second part of the rule is a reporting requirement. It's a one-time reporting requirement. It has to happen in 2021, and it's for larger fleets or fleets that facilities that contract vehicle services or have large number of vehicles at their facilities. This is the chart that shows you the vehicle class size as well as the percentage of sales that must be zero emission. So if you're looking at, say, the class 7 and 8 tractors, that's the large ones, the over 26,000 pounds, starting in 2024, the manufacturers of those types of vehicles are required to have a 5% of their total sales for that year be electric. This may be surprising to a lot of people, because I'm sure you haven't seen a lot of electric vehicles, electric trucks out there, but there are dozens of trucks that are in process right now. Some of them are actually being tested and on road. Many of you might have seen the one example that stands out, in my opinion, is the Tesla version. There's a Tesla truck out there that they, just like Elon usually does, he makes this odd looking truck. I think it's really cool, actually, but he makes it look different than anything else. And that's part of the reason that he does as well as he does, is that it looks cool. But that's an electric vehicle. That's an electric truck. And it's in process to start being sold here in the United States in a very short order. Anyway, so this is the sales requirement. This establishes the pathway to get to carbon neutrality by the 2045 timeframe. It already is being used by some areas of the state. You've got the San Pedro Bay ports, which would be the Port of Long Beach and the Port of Los Angeles, that are already doing some of this with their drayage truck fleets. In fact, the Port of Long Beach is almost all, or a lot of their drayage truck fleet is already zero emission. And if the manufacturers can't get to the percentage required, they do have an option of producing hybrids, plug-in hybrids, to get partial credit rather than that being a full zero emission vehicle. The one-time fleet reporting is only going to apply to those fleets that have 50 or more trucks, or brokers that direct 50 or more trucks, or any fleet that has an annual revenue of more than 50 million. And it also applies to all government agencies. What we're asking for is to report the number of these type of vehicles that you have and how they're being used. Why we need this information is for the other two rules that I talked about, the Knox omnibus regulation and the ZEV regulation. Both those things, a lot of decisions have to be made before those can be passed, and the decisions need data. So this rule has been put in place to get that data. So we're using it to match the fleet needs with the available zero emission vehicles, to determine the benefits to the local communities, and to facilitate infrastructure, because that's actually one of the biggest issues we have, is the infrastructure that's going to be necessary to power these vehicles. You got to have plug-in stations in order for ZEVs to work properly. Future zero emission regulations, we've got other steps that our agency is working on right now. By 2035, having all drayage and port trucks and last mile delivery government vehicles go zero emission. 2040, refuse trucks, buses, and utility fleets. 2045, for any other vehicles where it's feasible. We are focusing on benefits that are applied to disadvantaged communities. That's a big thing in our agency and has been for a while. And we're looking at all concepts we can possibly use to get to this, like green contracting, zero emission zones, purchase requirements, all manner of things that are being floated to try and get to this level. We got more information here. There's some web pages and some document pages that you can look at, as well as for the omnibus regulation, for the advanced clean truck, and for the zero emission fleet rules. So I do encourage you to take a look at this whenever you get the opportunity, because this is not just the future anymore. This is where we are. This is where we're going.
Randy, we did get a question that I'm not sure about. So I know ACT passed the board, but do you know if it was approved by the Office of Administrative Law already?
No, it has not been approved by the Office of Administrative Law. Typically, we're going through what's called the FSOR right now. FSOR stands for the Final Statement of Reasons. And Paul Arnejo, he's working on that right now. And really what happens there is people will ask us questions, and we have to make sure we answer all questions about the passing of the rule, and it goes to the Office of Administrative Law. And they've got actually a fair amount of time. I think it's like 6 months or something like that they can look through the rule and double check it. It hasn't gotten to the point where they've sent it back yet.
Yeah, I just tried to look if it was even on the docket on their website, and I didn't see it. So
no, I think I'm not as up on the timeline as I should be, but I think we've got to get through the FSOR before it actually goes there.
Yeah. Okay.
All right, so that's the part where I take a step back and Katie comes on. So I'm going to mute myself and go.
Okay, so we're going to start with the off-road portion of this presentation. And again, my name is Katie King. I'm with the California Air Resources Board with Randy. Okay, we're all set up. So in use off-road vehicle regulation. So unlike what Randy was just talking about with the truck and bus regulation, the off-road regulation does pertain to government agencies. I know we have a few in the audience, so I just wanted to make that clear that this is a portion of this presentation that would be applicable. So when we talk about the off-road regulation, again, we're referring to the engines, and it's diesel engines, which run on any form of diesel. So that includes biodiesel. Basically, any diesel fuel in a compression engine would be considered diesel fuel under the regulation. This also would apply if you're putting a different type of fuel into a diesel compression engine in an effort to not fall under the regulation. We have had people ask about putting kerosene into their diesel cycle engine in an attempt to not be regulated, and we don't recommend that, and it doesn't make you exempt in any case, so just avoid doing that. When we're referring to diesel fuel, that also includes red dye diesel. Red dye diesel is the same chemical composition as normal diesel. It's just taxed differently because it's not meant for on-road use. It's meant for engines that are used in construction, off-road, or stationary engines. The next criteria that an engine would need to meet is it has to be self-propelled, or the vehicle needs to be self-propelled. So what do I mean when I say self-propelled? The engine has to provide motive force for the vehicle. If you have an engine that drives a compressor and it's on a trailer, you would have to pull that trailer in order to move it from one side of a site to another. So that makes that engine portable versus mobile or an off-road engine. So that's a different regulation. In order for it to be self-propelled, the engine has to be capable of driving the vehicle. So my easy example of this is always a skid steer. It can propel itself around the construction site, doesn't need to be pulled. If the engine supplies power to something else, so if you say you had a drill rig or a crane, so long as it provides propulsion, it's considered a propulsion engine. In order to fall under the rule, the engine also has to be at least 25 horsepower. Sometimes we see mini excavators that are rated at 24.9 horsepower. That's completely intentional because it exempts them of this regulation. You have no requirements if you're under 25 horsepower. If the engine, so it has to be a true off-road engine to be included. We actually got some questions about this during the truck and bus portion of the regulation as well. There are a few exceptions where on-road engines are included in the off-road regulation, but they're explicitly outlined. One of the things that happens when we go through regulations, like Randy was just saying, the proposed regulations, is we go through a public comment period. During that period, we try to work with the regulated public to make the regulation more effective and to include things that we may not have initially thought of. So in this particular regulation, there were a few communities that participated that advocated to be included in the off-road regulation. The water drilling and gas drilling communities both participated in the regulatory process, and they made the case that their vehicles should be included in the off-road regulation. They never go off oil fields. They're not legal to register for on-road use. Basically, they're intended by manufacturers for off-road use exclusively, and therefore we included them in the regulation. Two-engine cranes are also in a unique position that they have an auxiliary engine. So that kind of creates a regulatory issue because, like I said earlier, that secondary engine is considered portable. It doesn't propel the crane, it's just an auxiliary engine. So it would be covered by the portable regulation. If we didn't make any exceptions for that, then the auxiliary engine would have been required to get a secondary permit unless we explicitly included them in the regulation. So that's what we did. Two-engine cranes are included in this regulation. Something important to note with that is that I'm saying this at the state level. It's completely dependent on what district you operate in, whether your local air district still requires you to get a secondary permit for that auxiliary engine. So no matter what, the propulsion engine is going to be covered under this, but your district may require you still to get an additional permit for an auxiliary engine in situations like cranes if it's over 50 horsepower. Two-engine cranes and water well drilling rigs are automatically included in the off-road regulation at the state level. For the two-engine cranes and water well drilling rigs, the engine can be any tier, so even tier 0, which is not always the case for other two-engine vehicles. You'll see at the bottom it does say certain other two-engine vehicles are included, but they have to meet certain criteria. So for other two-engine vehicles, these are the criteria that your vehicle has to meet in order to be considered off-road under the regulation. The first is that the auxiliary engine has to be at least 50 horsepower. The second is that the engine, well, we do it a little different order in here, but the engine has to be certified. So no tier 0 engines in this case are eligible. It can't be subject to the public agency rule. So If it's a public agency vehicle, 2-engine vehicle, it would not be applicable. No 2-engine sweepers, which typically do fall under the public agency regulation anyway. And then the auxiliary engine has to be designed with the vehicle or fully integrated into the design. So when we say that, essentially what we're getting at is you can't have a truck that you bolt a secondary engine to the chassis or add it on in any way after manufacture. In that case, it would be an on-road vehicle with a portable engine. So that secondary engine is going to need a permit based on state and local permitting. If you have a scraper for grading, those are considered 2-engine vehicles and can either be reported separately if they're detachable or as one 2-engine vehicle if they are not detachable. So your main takeaways for compliance with 2-engine vehicles is that regardless, both engines must be reported indoors. The secondary or auxiliary engine may require a permit with the local air district. Whether or not they're required would be determined by the local air district. Typically, the air district, if they do require a permit, doesn't have a preference on what type of permit is used, so you'd still be eligible for either a local permit to operate or a portable equipment registration program, a program permit in most cases, but ultimately it's a district decision, so we're always going to direct you to talk to one of your local air districts. There are 35 local air districts in the state of California, so just make sure you're doing some research and understanding what districts or district you reside in and determine if your equipment needs a permit with them. If you own a 2-engine vehicle and you have questions with reporting or what regulation that vehicle is covered by, you can always contact ARB staff and we'd be happy to help. But again, we will just not be able to tell you if that vehicle requires a district permit as well. So as Randy said earlier, there are always exemptions, or most of the time exemptions with regulations. The off-road regulation does have some exemptions. It does not apply to those vehicles that are used solely for agricultural or forest operations, and also does not apply to vehicles for personal use. So even if I have an excavator that's 300 horsepower that I use on my property, that's fine. If I rent that excavator out on the weekends, then it becomes regulated. The regulation also has some partial exemptions. I call them partial exemptions because the vehicles are not subject to the performance standards, but they are still required to keep records, report, and label. The most common option for partially exempt equipment is low use. If you have a vehicle that you can keep under 200 hours per year, it is exempt of the performance standards or the emissions portion of the regulation. It is still required to be reported and labeled. I'll get into specifics on low use a little bit later in this presentation, just because it is an option that people do like to use. So we want to make sure to give you all the information on that. The next exempt vehicles that we have are emergency vehicles, dedicated snow removal vehicles, and finally ag equipment that's used a majority of the time for agriculture, but not 100% of the time. This would be your cases where the equipment is used over 50% of the time for agriculture, but not all of the time. So unlike equipment that's used 100% of the time for agriculture, the partial ag vehicles still are required to be reported and labeled. So we'll get into this a little bit in more detail later in the presentation, but as a quick breakdown, the way that the off-road regulation works is that it's a fleet rule. So you report every piece of equipment in your fleet that meets the definition of an off-road vehicle under the regulation. This includes all the vehicles under common ownership, whether or not they're kept at the same facility. We then use a formula to create an emission rate for each piece of equipment in your fleet, which goes toward your fleet average. The emission rate is based on the emission of grams per brake horsepower of Knox that your vehicle emits. The nice thing is that the system you report in does all of this math for you, so you don't really have to worry about that. Once we have your average, we compare it to the fleet target. The target is a set number that will get lower every year, and that's based on your fleet size. So larger fleets have lower targets. Once your fleet emission rate is higher than your fleet target, that's when you're required to take action to reduce your emissions in order for your fleet to remain compliant. So again, the reporting system will automatically do that for you. It'll notify you when you're going to be compliant until, and then the reporting system automatically also excludes your reported partially exempt equipment. So again, the low use emergency vehicles, snow removal, and partial ag, even if those are reported, it will not include those in the calculation. The fleet sizes are shown here, and even though there are 3 fleet sizes, we're far enough along in this regulation that medium and large fleets have the same requirements. So any fleet that is over 2,501 horsepower will have the same requirements. If you have a small fleet, you will have a little bit less stringent requirements and a little bit longer timeline. So just something to keep in mind. Small fleets are those with less than 2,500 horsepower and also include municipality fleets in low population counties or fleets in captive attainment areas, regardless of the total horsepower of that fleet. All state and federal government fleets are considered large regardless of their total horsepower. A little takeaway from this would be that if you are able to keep your fleet under 2,500 horsepower, that could be beneficial to you just to extend the timeline and have less stringent requirements. Because again, the requirements in the compliance states are dependent on the fleet size. For a fleet to determine their fleet size, they must add up all of the off-road horsepower under common ownership and control. So if you have a few subsidiaries, all of the off-road horsepower from each of those subsidiaries would be added up to determine the overall fleet size of the company or corporation. There are 2 kinds of reporting under this regulation: initial reporting and annual reporting. Initial reporting is just referring to the first time a fleet enters and reports all the vehicles into the system. The initial reporting deadlines have already passed. Fleets are still encouraged to report as soon as possible to avoid fines. So if you make an account tomorrow, you're not going to be flagged that you completed your initial reporting late, because reporting is required for this regulation. You can report for free online using the Diesel Off-Road Online Reporting System, or DOORS. This is the quickest and simplest way to report, and it satisfies all of the off-road vehicle reporting requirements, and the best part, retains all the data for future reporting requirements, so you don't have to re-enter your data every year. We will ask for information about your fleet as well as the information you're reporting. Something to note with that is that we don't validate most of the data, and what I mean when I say that is that if things appear to match up with the information you reported, we're going to accept that information into the database. If you misenter any of that information, it's your responsibility to verify and correct it. If an inspector finds the misreported information or a vehicle that's not registered, they will issue a citation. Enforcement does have access to the information you input even when they're inspecting in the field. So again, if you're caught with unreported equipment or false information in the field, then you will receive a citation. If you have all of your vehicles initially reported, you don't have to go and add those vehicles again every year, but you do need to annually certify that there have been no changes or update if there are changes. The annual reporting that's required is required for every fleet size, and it's called the Responsible Official Affirmation of Reporting, or ROAR. If you have anything to update, this is when you make sure that it's updated in your account. The person that's ultimately responsible for the fleet should go in every year and certify that the information that's in the DOOR system is correct. If you have a low use vehicle, this is also the time when you would go in and report the hour meter readings to say that you're still under that limit for the low use vehicles. The same is true for majority agricultural vehicles, or if any changes have been made since initial reporting. So ultimately, the goal of ROAR reporting is to make sure that the fleet is updated. Obviously, we recommend updating throughout the year, partly because it is a requirement, but also because if you have a lot of changes at the end of the year, it's going to add up and it's going to take a really long time to update your report when you could have just been doing it throughout the year. ROAR reports are due annually by March 1st of every year, and vehicles that are brought into the state or added to the fleet throughout the year must be reported within 30 days. So there are some labeling requirements after you've reported your vehicle. Again, you have 30 days to register your vehicle indoors once you obtain it, and then you have 30 days after that to get the label on it. Once you report a piece of equipment into DOORS, the system will generate a random alphanumeric number. It's called your Equipment Identification Number, or EIN. Once that number is generated, you're responsible for labeling it again within 30 days. So this is different than the PERT program, if you've had any experience with that, where you register and then are sent the PERT placard and the sticker that goes on your equipment. This label for the DOORS program is something that you have to create yourself. You can acquire them from dealerships, private companies, or even paint them on yourself, so long as they meet the standards, which typically what we're looking for is legible white lettering on a red background. There is a list of vendors for EIN labels on the website. That EIN that is generated should stay with the piece of equipment for the life of the vehicle. So even if you sell that vehicle, the EIN goes with it. The reason for that is I always call it a birth certificate for the vehicle, but essentially we don't want duplicates in the reporting system. So at this point in the regulation, again, all vehicles should be labeled unless it was just brought into the state within 30 days. As of 2013, labels were required on both sides of the vehicle. It used to be just one side of the vehicle when the regulation was first implemented, but somehow the opposite side of the vehicle was always pointed outside the job site at the end of the day. So we had to amend the regulation, and now they're required on both sides. The reason for that is typically 9 out of 10 times the inspector doesn't want to come onto the job site if they can help it. It's a much better option for everyone to just do a drive-by inspection and make sure that everything's compliant. They can check the EIN, run it in their computer, and just see that it comes up normal. Because again, it's a safety issue and a time sink if we have to interrupt your work. So the basic specs for the label directly from the regulatory language are that the EIN should be white on a red background, shall be located in clear view on the right and left side of the outside of the vehicle. Each character shall be at least 3 inches in height and 1.5 inches in width, and the EIN shall be maintained in a manner that retains its legibility for the entire life of the vehicle. The reason that I specifically like to point out that part is we're not a lot of the time going to go out there and measure the height of the letters, but they are going to make sure that it's in readable condition and correct colors. So if it's getting a little sun damaged, or if you notice it gets scraped off at a job site, just make sure that you're replacing it as needed. Additionally, the captive attainment area fleets must make the background green rather than red. The two main things that happen when we see the green labels outside of the designated zones, one is that if somebody buys a piece of equipment, it already had the green label on it, and then they just start using it in their fleet. Make sure that if you buy a piece of equipment from a captive attainment area, you're totally fine to do that. Just make sure to replace the label with the same EIN numbers, but the red background and the white lettering if you're not in a captive attainment area. The second thing that we'll see happen is if somebody has a large fleet with portions, they'll pull equipment from another site in a captive attainment area and they'll use it outside of it. That's not allowed per the regulation. So if you do have fleet portions and you have some captive attainment equipment, do not use it outside of the captive attainment area. And the captive attainment area is the ones that are in Knox attainment, and they're listed in the regulation. So some of the issues that we see when it comes to labeling, typically the number one is there's no label at all or only a label on one side. We also frequently see illegible labels. So for example, like I said earlier, if the label is partially scraped off, sometimes there'll be an incident on the job site. The vinyl labels in particular eventually get very sun damaged and fade to the point where they're unreadable. In this particular photo on this slide, you can see that the person applied the EIN inside of the operator cage. If this was in use, this would make the inspector think that the machine isn't labeled. And it also fails to meet the labeling standard since the regulation states that the label must be in clear view. Another issue we'll see is when people create a new EIN for a piece of equipment that already has one. So as you can see, this skid steer has 3 labels on it. That's too many. We just need the one. It's a big red flag to an inspector if they see something like this. And in this particular case, all the other equipment on the job site shared the same labels. So again, 1 EIN per piece of equipment, make sure it's the correct one. In this particular case too, if you had multiple of the same type of equipment, make sure you're matching the serial numbers too, because if we're seeing something like that and see mismatched serial number to the EIN, then that's going to raise some questions as well. We also see incorrect EINs being applied. So sometimes it's just an issue of, bad handwriting. In this particular case, you can see that top label started to get pretty sun damaged. It was getting hard to read. So they did the right thing. They went and replaced it. But probably whoever wrote it down made their G look a little bit too swirly and it looked like a 6. And then they ended up with that second label there that's the incorrect label. So EINs are always going to follow the same pattern as well, which is 2 letters, 1 number, 1 letter, 2 numbers. If you ever see a piece of equipment that you own that deviates from that, you probably want to look into it because it probably just was misgenerated. There are multiple idling limits for California. Truck and bus has idling limitations. School buses have idling limitations. Off-road is no different. In this instance, the idling limitation is actually built into the language of the regulation. The way that an inspector will look at this is if the engine of the vehicle does not need to be on to perform the function of that vehicle, it's not essential idling or it's unnecessary idling. There's a 5-minute limit on unnecessary idling. A different way to say that is if the idling is necessary to perform the vehicle's function, there's no limit. But again, unnecessary 5-minute limit. A word of warning, I would say, with the no idling limitation for necessary function is if you do happen to get caught in an inspection with your off-road vehicle, any given inspector is not necessarily going to know what your piece of equipment requires as far as idling. If it's something obvious, like you have a painter and a boom lift and they have it running while they're doing their painting, obviously they may need to move that. That's totally fine. A different scenario would be if you have an excavator and it needs a 30-minute cool down period per the manual, that's still considered necessary idling. But if an inspector walked up and saw an excavator running and there's no operator inside, they're just going to start their timer. That's not to say don't perform the operation, just be aware of that. And what I would recommend is any equipment that you have like that, where it has a necessary idling operation, that's maybe not so obvious, just keep some sort of record of that with the piece of equipment. And that way you can provide an inspector that information immediately, and it may actually prevent you from receiving a citation. So some valid reasons for idling are active queuing, maintenance, safe operation of equipment, which includes warm up and cool down if required by the manufacturer. This also applies to vehicles that have DPF and are undergoing a regeneration, which frequently requires a high idle for the off-road equipment. You may be required, again, to prove this equipment is going through regeneration to use this exemption. If you have a medium or large fleet, you have an additional requirement as far as idling goes, and that's to have a documented idling policy. This requirement isn't specific, so you can decide how in-depth that policy needs to be. It may be a single piece of paper that says, don't idle, that you provide to all your operators. It could be a document that lists every allowable idling instance for each vehicle type in your fleet. Again, that's totally up to you. This isn't something that will be asked for in an inspection, but if you were ever audited, it will come up in the audit. There are some examples on our enforcement page if you want a layout for or a template for your idling policy, but again, these are just guidelines. You're welcome to make this policy whatever you like. If you are going to sell equipment to someone who will operate that equipment in the state of California, this exact paragraph, the sales disclosure, must be included in the sales document and retained by you for 3 years after the sale. So again, this is specifically for if you're selling to someone within the state of California. If you are 100% confident that piece of equipment is being sold out of the state or out of the country, you are not required to include this in that instance. I would recommend putting it in there anyway, just to safeguard yourself, because you never know where the equipment's going to end up. But many of the large auction houses already include this language in their documents, but it's always a good idea just to verify with them if you're having them sell your equipment and get some confirmation. Additionally, if you do sell multiple equipment types, we do have a paragraph that encompasses on-road, off-road, and portable equipment, and we can provide you that language if that's something that you're interested in. So the off-road regulation includes restrictions on adding vehicles, or as more people know it, a tier ban. When this rule was implemented and signed off by the federal EPA, the tier ban was one of the first things that applied. So when I say a tier, that refers to the certification of an off-road engine. We have this information in text version on the next slide, or in this slide, and then I'll show you the charted version on the next slide, just because I think it's a little bit easier to comprehend. So this is the tier ban chart. Essentially, what it's conveying is that depending on the size of your fleet, you're limited on the age of the equipment you can bring into your fleet. Your exact tier is determined by the engine year and size. If you have a medium or large fleet, you can no longer add below a tier 3 engine. If you have a small fleet, you can no longer add below a tier 2 engine, and in 2023, you will no longer be able to add below a tier 3 engine. As the engines get cleaner, the tier number gets higher. So currently the highest rating is a tier 4 final engine. That's not to say that if you have a medium or large fleet, you can't own any tier 1, tier 2, or even tier 0 equipment. Remember, this is a fleet average rule. So long as you owned that equipment before the cutoff date and have it correctly reported, it will affect your fleet average, but there are not currently any ownership restrictions on that equipment. So what those older vehicles will do is they'll drive your fleet average up and make it more difficult to comply long term. Some of you may be confused because you've added an older vehicle after the tier ban date. So why would the system even let you do that if there's a tier ban? There's one scenario where you can add vehicles that would otherwise fall under the tier ban, and that is if you purchase an entire fleet. So long as that fleet was compliant on the date of purchase, you can actually add all of those vehicles into your fleet, even those that would have had the tier ban apply otherwise. If you purchase an entire fleet and they are not compliant, then the tier ban does still apply. Regardless of the situation, because of this, when you're adding a banned vehicle, the system will throw up a warning flag that says, this is a banned vehicle. Are you sure you want to add? You can click OK, and it will add the vehicle to your fleet. Be aware that these vehicles are highlighted when enforcement looks at your fleet. And if you added a banned vehicle after the tier ban that didn't apply to the purchase of an entire fleet, you will likely be subject to an enforcement action. Additionally, the tier ban doesn't apply to partially exempt equipment we discussed earlier, but if that equipment was purchased after a ban date and then you choose to use it for another purpose, the tier ban does apply. An example of this would be if I have a vehicle that I use on my farm and I use it for agriculture 75% of the time, that vehicle is considered partially exempt. If I decide I want to stop using that vehicle on the agriculture side of my business and only use it on the production side, I would have to remove the partial exemption and then the tier ban would apply. If that was a tier 0 or tier 1 vehicle, I may run into some trouble removing that designation and adding it to my fleet, depending on the purchase date. So when you're adding equipment, you're affecting your ability to comply. There are 2 different ways the system allows you to comply. The first is fleet averaging, which takes into account your overall fleet emission average. And the second way is the best available control technology. Whatever one you use, you have to take action before January 1st of each year in the compliance timeline. So fleet averaging is what we've more or less touched on for this entire presentation up to this point. It's based on your NOx emission rate of each engine in your fleet. There's a formula that we use to calculate the average using the emission rates, and then we compare the average emission rate of your fleet with a target that is set automatically. All of this is done in the DOOR system. You don't have to calculate it yourself. If you are curious of a breakdown in the math, it's shown in the compliance snapshot page. It's important to note that your target emission rate will get lower over time. If you are at or below the target, your fleet is compliant. Emission factors are defined as the emission rate of a device in grams per brake horsepower, and the emission factors are predetermined based on the engine model year and the horsepower of the engine. So this information is listed on your emission control label, and it's all based on the certification from the federal government. So let's talk about the secondary method you can use to comply with this rule. This is called the best available control method, or the BACT method. BACT ignores your fleet average completely, and you do not have to meet the fleet target through the usual methods. BACT requires a turnover each year of 10% of your fleet, and that's regardless of fleet size, 10%. You have to make that turnover prior to January 1st in order to make your fleet compliant. This is required to be applied to older vehicles first, so Tier 0 and Tier 1 vehicles first. There are exemptions. These are vehicles that don't qualify for BACT credit, and we don't want you altering these vehicles. So that includes vehicles that are less than 10 years old and specialty vehicles. Whether or not a vehicle is considered specialty has to be determined by ARB staff. If you think your vehicle is specialty, you can contact the DOOR staff, but in order to get that designation, just as an FYI before you even reach out, whatever job you use that vehicle for cannot be done by any other piece of equipment or any other combination of pieces of equipment. If the vehicle has a particulate filter that came with the manufacturer, we don't want you altering that vehicle, so it's not eligible for BACT. Tier 4 interim vehicles already meet the standards of the regulation and therefore do not generate BACT credit. For medium or large fleets, if you installed a filter on a piece of equipment, that piece of equipment is not eligible for BACT until 6 years after the installation of the filter. Something to mention with that is that if you installed filters prior to 2013 and you received early credits for that filter installation, that equipment is still eligible for BACT credit. So you can kind of get double credit on those ones. This is for those fleets that started complying with our initial version of this rule that required filter installation before we lost the lawsuit on this one. We didn't want to penalize people for trying to be compliant early, so we offered those credits for the filter installation. We do have an additional option if you have an ultra small fleet or a micro fleet, which would be those with less than 500 brake horsepower total. You can follow an alternative compliance path. That compliance path is to phase out Tier 0 and Tier 1 vehicles, starting with 25% in 2019, 50% by 2022, 75% by 2026, and no Tier 0 or 1 vehicles left by 2029. This is not considered the fleet average method or the BACT method. It's a completely separate way to comply. The total horsepower in this case does take into account vehicles that would not otherwise be subject to the performance standards. So again, your low use emergency vehicles, they do count into your total horsepower for this option. And this option extends your timeline a little bit and allows you more time to meet the Tier 2 standard. You cannot opt into this option yourself. You have to work with the DOOR staff in order to opt in. So if you believe this applies to you, just give us a call and we can help determine if this is an option for your fleet. So now let's get into low use. If you have a piece of equipment that can be operated for less than 200 hours per year, or if you have a piece of equipment that already operates less than 200 hours per year, you can benefit from using one of the low use options. If it's a 2-engine vehicle, both of the engines have to stay under 200 hours per year. A lot of times we'll see those vehicles where maybe the propulsion engine doesn't operate very much, but the stationary portion of it, like the drill or crane, that's the main use, so that one will go over the 200 hours. There are, again, 2 options for low use vehicles. Both of these options require the equipment to be equipped with a non-resettable hour meter in order to accurately report the yearly hours. If you go into the system and you opt into low use, it automatically puts you into the year-by-year option. The reason for that is because it's the more flexible of the 2 options. It's flexible in a couple different ways. So the first way is that we don't just use last year's hours to determine your usage. We'll actually take the previous 3 years and have a rolling average of those years. If you can use the vehicle, let's say you used it 250 hours one year, 100 hours the next year, and 205 the year after that, that vehicle is still compliant even though it went over 200 hours a couple of times because it's a rolling 3-year average. If you go over the rolling 3-year average, so if you're over the 200 hours for the 3 years, that vehicle goes back into your fleet. It does affect your fleet average, but the tier ban doesn't apply and there's no citation. Alternatively, if you designate a vehicle as permanent low use, you're essentially guaranteeing us that that vehicle is going to be used at a negligible level. The way that I like to think of it is essentially it's almost as if you've sold it. We're going to give you credit as if you sold that vehicle. You will receive a backed credit for retiring the vehicle, but again, it's a contract. You must stay below 200 hours per year. The benefit to this is if you're not going to meet your fleet target on any given year, this is a really easy and cheap way in order for you to get backed credits. So you don't have to pay for a filter installation. You just have to commit to using this piece of equipment under 200 hours. However, because of this, there is a downside to permanent low use, and that is if you go over 200 hours, your backed credit will go away. The adding vehicle restriction, the tier ban, applies because, again, you told us you sold it. Additionally, you will most likely receive a citation for exceeding the hours in that scenario. So this is a list of resources for the off-road regulation. The off-road zone is a website that we keep up to date with information and training options. It's related to truck stop. So if you're already on the truck stop, you can just hop over to off-road zone. I do recommend looking there first for questions. There's a lot of FAQs and resources available on that webpage, and it's pretty easy to navigate. We also have the DOORS hotline staffed Monday through Friday, or you can email the DOORS team at doors@arb.ca.gov. They're really knowledgeable. I still ask them questions occasionally on complex stuff, so highly recommend it. But that is the off-road regulation for today. And then we'll pass it back to Randy for the portable equipment.
All right, so we're back to the last section of today's training. I'm going to be talking here today for the next half hour or so about the Portable Equipment Registration Program, or PERP, and hopefully you guys all need this information. Let's talk about what this program is. Let's see here, make sure it works right. So quite some time ago, we had some issue with one of the categories of engines and units that local districts had to enforce air pollution regulations on as compared to state regulations. So that's dealing with the portable equipment system. So if you were to look at all the types of engines that federal EPA certifies, they can be fit into one of 4 basic categories. You can have an on-road mobile engine, which we already talked about in the truck and bus rule. You can have an off-road engine, which Katie just finished talking about. You can have a stationary engine, which doesn't move, is bolted to the ground, and that's a completely separate kind of thing. Or you can have an engine that is mobile, but it doesn't actually have the ability to move itself. It has to be towed from one location to another. That's called a portable engine. Now the glitch in the system, because these engines all can be fairly, you could have the exact same engine in all 4 categories, seemingly, but the glitch is in how you use them. One of the things that I did not say, and actually came up in the questions box earlier, was the fact that ARB regulates engines based on how they're certified. So if an engine is certified to an on-road use, it doesn't matter how you use it, it's going to be in the on-road regulation, so on and so forth. With portable engines and stationary engines, as opposed to on-road mobile and off-road mobile, the biggest problem we have with regulation and with enforcement is who is actually doing the enforcement. So with on-road mobile and off-road mobile, the enforcement happens at the state level. So a state inspector, like some of the ones that work for our office, they were doing most of the enforcement with relation to those types of engines. In Katie's case, when she worked down at San Diego, we had an agreement with that district to do those type of inspections, so they were doing them. But in most cases, it's going to be the state inspector that handles that. For stationary and portable engines, all the enforcement happens at the local level. Now, as far as the stationary engine is concerned, that really doesn't mean anything because that engine's never going to move. So if it resides in one particular district, that district is always going to have authority over that particular engine. With portable engines, they're enforced by the locals, but the fact that they can move around causes problems because they can cross boundaries into other districts. In the state, we have 35 local air districts. We have one in Sacramento, we have one in Placer County, we have one in San Diego, we have one district that encompasses the entire Central Valley from Stockton all the way to Kern. So they handle, each of those districts handles the stationary and the portable sources in their particular area of influence. With portable engines and stationary engines, those districts require permits in order for anybody who owns an engine like that to actually operate within their sphere of influence. Now, like I said, with a stationary engine, that wouldn't be a problem because that engine's always going to be under the same district. It's going to be staying in the same spot. With the portable engine, a district can require a permit, and then if that engine moves into a different district, that other district can also require a permit. And since there are 35 local districts, it is theoretically possible to have one piece of equipment, one portable engine, actually have multiple permits or 35 separate permits. You might think that's crazy, but I've actually seen one of those engines back when I'm trying to think of the name of the company. It's MCI. MCI was what Sprint was before it became Sprint. And MCI used to have these giant portable generators that were on the back of trailers that were hauled by semis, where they could take it to anywhere in the state to run one of their cell towers when there was a power outage of some type. So they had to have permits for every district because those units could be taken anywhere in the state. In any case, that's a problem. It's a problem because each of those permits from each district can cost up to $1,000 for 1 year. And if you're going to operate in multiple districts, you're going to have multiple permits for one piece of equipment at the cost of whatever the permit cost of that particular district. Let's just say $1,000 per year. As you can see, this can be a problem. So several years ago, the local districts and the manufacturers of this kind of equipment actually petitioned the ARB to solve the problem. And what we came up with is this program that I'm talking about here today, the Portable Equipment Registration Program. And what this program does is it provides a registration in lieu of a permit that offers you several things. It offers you, number one, the ability to use the same permit or registration anywhere in the state. You don't have to get a new registration when you move the unit around. The second thing it offers is a longer term for the actual registration. Most district permits are only good for a year. These registrations are good for 3 years. And the final thing that it offers that I'll talk about today is the fact that the cost of the registration is typically going to be less than the cost of a permit. So a registration can cost anywhere from $400 or $500 up to $700 or $800 for the entire 3-year period. So anybody that has one of these portable units is going to want to get a registration rather than go with a district permit because it provides more flexibility and is less expensive. There are some problems with it. See, the biggest problem is still that it's a state registration. So the State of California Air Resources Board is the one that issues these registrations, but the enforcement still happens at the local level. So there sometimes can be some differences of opinion between what the locals believe needs to be enforced and what the state actually writes into the permit. That's neither here nor there. I'm going to tell you straight up that the local district has all of the control. If you have any questions related to what your permit, your registration requires, and what you need to do, whether you even need to have a registration, it's always going to default, in my opinion, to the local district. It is a state program though, and because it's a state program, the state gets to decide what can actually go into this registration program. And that's where another issue is created, because we actually will allow two different types of equipment to be in this registration program. One of them is very easy, the engines, portable engines. And this would be any engine rated to greater than 50 horsepower. It doesn't matter what kind of fuel it runs on, as long as it's greater than 50 horsepower and it's a portable engine and meets certain other conditions, we will allow this in this registration program. Everybody can understand that. The part that most people have trouble with is something called an equipment unit. Now, equipment unit requirements vary depending upon where you are in the state. So each district has their own determination as to what they say needs to have a registration or a permit. But let me explain to you what an equipment unit is first, so you understand why it's a problem. So an equipment unit is defined as not an engine, so it cannot have any internal combustion. An equipment unit by definition has to be portable, so it has to be moving around like a portable engine, but it's not an engine. And an equipment unit has to produce dust, or PM10. So anything you can think of that you can haul around that is not an engine and produces PM10 can be considered an equipment unit by a local district. It gets even a little bit more complicated because it does not necessarily have to be disassociated from an engine. And I know that's a complicated way of saying this, but basically you can have a single device that has both an engine and an equipment unit, and it's one device. I'll give you a couple of examples. One of the bigger examples that I use most of the time, because I know most people have seen this before, if you've ever seen any road reconstruction where they're tearing up an old road and putting new tar down, you've probably seen the machine that they bring out. It has this, it's on tank tracks, and it has a big grinder on the front end, and it has a conveyor belt on the back end, and it has an operator sitting on top of it, and it's very slowly going over the road that's being resurfaced, and it's grinding up a section of the road, and all that material is being thrown back on the conveyor belt, and there's usually a truck behind there collecting that, because they take that back and they reuse it to make more asphalt. Well, that device, that unit, actually has an off-road engine. It's on tracks, so it's not an on-road device, so that would fall under the on-road regulation. But that grinder on the front end, if you look at it and look at the definitions that I just gave you, number one, that grinder is not an engine. Number two, it's moving, it's on tracks. And number three, you better darn well believe that that thing produces a lot of dust, and a component of that dust happens to be PM10. So nearly all districts in the state of California, if somebody is using one of those grinders, they require a permit for the grinding unit itself, even though it's part of another piece of equipment. Another example would be a tree, not a tree trimmer, but the grinders, the unit that they throw all the branches into. That has an engine. It's on wheels. Usually it's being towed around. So it's got a portable engine. That portable engine needs a permit or a registration. The actual grinder portion of that also is portable. It is not an engine. It's being run by the engine, but it is not an engine itself. And it certainly produces a fair amount of dust. So it could be considered an equipment unit by some local districts in the state of California. And the owner of that unit could be required to get 2 registrations for 1 unit. So you can see, hopefully, why this is an issue. And as I said before, these equipment unit requirements vary by district. I and Katie might have more experience with this because she used to work in a local district, but I cannot tell you whether or not your equipment unit needs to have a permit. You need to talk to your local district. The Air Resources Board will issue the registration, but again, it's enforced at the local level. All right, and the reason I'm talking about this today primarily is not just because it's a program that we offer and have legislation over, but it also had some modifications that were done to it back in that became effective in 2019. So the eligibility for equipment units, in order to be eligible to get a registration, it's going to have some type of particulate matter control. Generally speaking, that's going to be some type of water spray nozzle or something like that that's going to remediate the dust. For the engines, there are several different possibilities. If you're bringing a portable engine into California for the first time and it's never had a permit from a local district or a registration with the Air Resources Board, there are only certain ways that you can get a registration for that. The number one way is if it happens to be whatever the current tier is for that engine. For most engines, Tier 4 final is the current tier. So if you're bringing a new engine into California, it probably needs to be Tier 4 final. There are some alternatives to that. If you have something called a flexibility engine, this would be an engine that was built at the time when a tier change happened within the requirements for a particular size of engine. You'll know you have a flexibility engine because it will have a text on the actual engine label that says flexibility engine. Those are something, because of the federal program that allows those to exist, that we will also take in as an engine with a registration. If you have an engine that is part of a two-engine vehicle for either the off-road regulation, the on-road truck and bus rule, or the harbor craft regulation, because those rules actually encapsulate the secondary engine's emissions as well, we will take those typically regardless of what the tier is, except we do not accept Tier 0 engines in that case. If you have an engine that is approved for hazardous locations, that would be a location where there's an explosive hazard. In this case, you would be able to get a registration for anything Tier 3 or below, because primarily or generally speaking, nobody wants to put an engine in a hazardous location that has a diesel particulate filter attached to it. And the Tier 3 engine was the last engine type or certification that did not include that. It would be a hazardous issue to have something that can get up to 1,000 degrees, Fahrenheit in a hazardous location. So we will allow that. Engines that are used on dedicated two-engine snow removal vehicles are also allowed in this, because those are generally going to be exempt from any of the requirements we have, primarily because of the temperatures that they operated in. And there are some stationary or spark ignition engines that meet certifications for on-road standards, the model year 2007 standards, that are also built into some of these portable devices. We will allow some of those to be registered in our system because they're meeting current on-road standards, but they have to be listed on a table that's part of the portable equipment registration program website. If you want one of these registration, the application process has always been done through paper. We are currently, and I really don't know how far we're into this, but my understanding is we're not fully online with this process yet. It's still a hard copy paper application that you have to fill out. You have to send in that application. Do not send any payment in with the application. We will not accept a payment or even ask for a payment for one of these registrations until after we have a complete application and we know we're going to issue the permit. There's some reasoning behind that, but let's just put it this way. We got audited and we got in trouble, so we don't do that anymore. If you send in an application that has missing or incorrect information, we're going to send it back. And we're not going to do anything with your registration until we get a complete, fully correct application. Once we get that, we legally have 90 days to deem it complete and send you the registration. Usually we do it a lot faster than that. Usually it's a couple of weeks at most, maybe a month. We had a little bit of a lag last year and the year before because we were going through the modifications, but we have since come to the place where we're now back on our regular track for approving these permits. And if you try to submit a registration for a Tier 4 final engine, we are probably going to issue a temporary registration nearly immediately, because we know that that's going to be one that is going to get a registration. The labeling requirements are the same as they were in the previous version of this rule. When you get a registration from us, you're going to get a placard. You can see some examples of the placards for the new placards right there. And actually those are all new. So if you have an older example of this, it won't have the new logo on it. It'll have CARB's old logo and it'll be green. That is still valid as long as you're within the 3-year time period that the registration is good. But the next time you go to renew that registration, we're going to send you a new placard. It's going to be color coded based on the tier of the engine. You can see the color codes here. The Tier 1 engines are color coded to red. The tier 2 is brown, the tier 3 is green, and the tier 4 is blue. You'll understand why we're color coding those in just a second, but that was a request from the local districts, who again are doing the enforcement, because they had to make determinations in the field as to what the tier was, and it was very difficult just looking at the documentation. Speaking of documentation, that documentation, the registration, must be kept on site with the unit. By on site, I don't mean in the office. I mean a copy of the documentation has to be with the portable unit that is registered. There's a very good reason for this, because these are issued by the state, and when we issue a registration, we do not send it to the local district. We send it to the owner of the unit. However, the local district is doing the enforcement. So they have no idea what they're looking at unless they have the document in front of them that says this is what is supposed to be here. That's why you need to keep a copy with the unit. There will also be a sticker. You can see the sticker on each of these. It's orange and black. It has a date on it as well as a registration number. So that sticker, you're going to get 2 of those. That is like a DMV sticker. It actually won't come off whole if you try and take it off, but that has been a problem with people trying to get these things stolen. So we send you 2, one of them keep in a safe place, and the other one is supposed to go on the placard itself.
Hey,
if
Randy,
you're going to, yes,
do you know if the registration fees went up for portable equipment?
they did in 2019, yes.
Okay, but so since it renews every 3 years, then it's also possible that people are just seeing that increase
Yeah,
for the first time.
yeah, that's correct. When they redid the regulation and the program, they actually raised the fees by about 30%. So it went from being like $320 for an equipment unit to $480 or something like that. And it went from, I think it was $500 or $600 for an engine to $700 or $800 for an engine. So yeah, and if you're still in your first 3-year period, when you get that renewal, the fees have gone up. Was that it?
Yep, that's it for now.
Okay, good deal. All right, so let's talk about something that happens fairly often and people don't pay attention to it. So if you are in the market for a portable engine and you're deciding that you want to buy a used one from somebody, one of the very first things you should do is make sure that that engine is currently registered either with ARB or has a current permit to operate from a local district. Because if it doesn't, and it happens to be a lower tier engine, you're not going to be able to get a registration or a permit for that unit. So if you have an engine that you're either selling or you're purchasing for somebody that already has an existing registration, there is a process to change the registration from the previous company or owner's name to the new company or owner's name. It has to happen within 30 days of the sale. It's called Form 6, and you have to submit it to the Air Resources Board, and if you are buying from an equipment dealer, they should know all about this. But the idea is we want to make sure that you can keep that registration going and make sure that you can still operate that engine legally. If you go beyond the 30 days, it becomes a new application process. And if you remember what I said about which engines will be accepted, if it's not a brand new engine, it's not going to be accepted. So even if it had a registration before, just make sure you stay on top of that. There are prohibitions that, which means there are certain things we will not allow to be registered in our program. Now, for equipment units, the basic prohibition is that we will not register any unit that emits something called a hazardous air pollutant. Hazardous air pollutant is a toxic material. That's the federal designation for toxic airborne contaminant. And the reason I'm showing you the picture that's on the screen, because that's serpentine rock, and serpentine rock is endemic to the state of California. It's all over the foothills of the state of California, and it's a problem for construction working around it because it contains typically a fair amount of asbestos. So if you were trying to get a registration for a grinding unit of some kind that was going to work in the foothills, and it was known that there was serpentine rock, which would have to be explained in your application, we would not issue that application. You would have to get a special use permit from a local district in order for that to work right. For engines, it's all about typically where the engine is connected. So a generator is not allowed to be connected to any power grid source unless there are certain conditions. And I've listed the conditions right here. Typically, it's going to be emergency events like unexpected power loss, If you have maintenance and repair operations, if there's a temporary replacement of a stationary generator or some electrical upgrades. You have to be aware, though, that even though I'm listing these here, there are some local districts that will not allow this under any circumstance. So talk to your local district before you rent a generator for a purpose that connects it to the grid. I was at a place where, down in the Central Valley, where a Kmart had a backup generator that went bad, and they brought in a portable generator without contacting the district while they got a new generator. And they wound up getting a citation from or a notice of violation from the local district because they didn't, first of all, they didn't tell them that happened, and second of all, that the use that they were doing was not allowed. State portable units may not be operated as part of a stationary source, at least not for any longer than a specified period of time. The general time limit on operating any portable device in the same location or as part of a stationary source is no more than 12 months or 365 days. If it happens to be a diesel engine, it would be less than that because those engines are covered by a different regulation, which I'll talk about in just a minute. And again, if you're unsure, before you do it, contact your local district. The last thing I want you to have happen is get a citation or a notice of violation from a local district because you didn't check to see what was actually legally allowed for these portable units. Now let's talk about the portable ATCM. ATCM stands for Airborne Toxic Control Measure, and it is for portable diesel engines. So it only affects portable diesel engines, and they have to be at least 50 brake horsepower. As Katie was saying earlier, that's why there was a bunch of diesel engines and other engines that came out that are less than 50 horsepower. They might be 49.9 horsepower. That was done precisely to get out of regulations like this. But in this case, there are a number of these type of engines out there that are at least 50 brake horsepower and they run on diesel fuel. Because diesel is the problem I spoke about right at the beginning of this class. We've got the particulate matter and the NOx, the toxic emissions. So we're trying to get rid of that particulate matter, and this ATCM does that, and it is designed to do that in several ways. We're trying to get rid of the older engines, so this regulation already has gotten rid of the tier 0 and 1 engines. If you have a tier 0 or tier 1 engine, portable diesel engine, then you're already out of compliance, most likely. It restricts these older engines from entering the state of California, and it has fleet emission reduction requirements. In fact, the new regulation does a phase out, which I'm going to show you in just a second. So if you have a diesel engine, your requirements for the ATCM are going to be listed on your registration from ARB, and the district will enforce those when they read through that. As I said, the current schedule for this ATCM on getting rid of older engines is a phase out instead of a fleet average. It used to be a fleet average, and by that I mean we would take all the diesel portable engines that you had that fell under the regulation, and we would do an average emission rate for your fleet, and then we would restrict your emission rate for your fleet, and it would go down over time so that you would have to clean up your fleet. That didn't work out so well. So one of the changes that happened in the redoing of this whole program was to take it from a fleet average and turn it into just a phase out of older engines. The tier 0s and tier 1s, as I said a few minutes ago, are already phased out. There have been, let's see, the old fleet averages are gone, as I said. In the new standard, any engine removed from service in California, according to the new phase-out schedule, is not allowed to be sold to anybody in the state of California. And we took away the fleet size requirements. So there used to be 3 different fleet sizes. Now there's only 2, and it's revolving on whether or not you have 750 brake horsepower or less or more. And if you have less than 750, you're considered a small fleet under this regulation. If you have 750 or more, you're considered I'm sorry, that's wrong. If you have more than 750, you've got your large fleet. Anything 750 or below is considered a small fleet. You still can retrofit some low use and emergency use engines to make them exempt from the phase out, but that's something that requires a notification to the Air Resources Board. And there are some fleets in the state of California that are considered large and are still following a fleet average. There's no way to get into the fleet average requirement right now. It's something that had to be applied for a couple of years ago. This is the phase out schedule. So I don't need to read through this whole thing. I just want to point out a couple of things. If you look at the very first row past the title rows, you've got tier ones. That's the tier one of the engine, or the tier of the engine. Those tier ones for large fleets and for small fleets were phased out as of January 1st, 2020. So the beginning of this year, if you had a tier one engine in operation, a diesel tier one engine, it became illegal. So that color-coded placard that I showed you before, the brown placard, no, the red placard, it was red. If a local inspector sees a red placard operating in the state of California and turns out to be a diesel engine, there's a problem. There's a problem because there's very few reasons why that should actually happen. If you have some larger rated engines, more than 750 horsepower just by the engine itself, and it's diesel, you still got at least a year and a half before you have to get rid of that. But those will be phased out as well. And as you can see by looking at this, by the end of this decade, you're going to have primarily nothing but tier 4 interim and tier 4 final engines in operation, for the most part. The large fleet option I was telling about is right here. These are engines that, fleets that applied for by June 30th of last year to stay in their fleet average. So they have this standard if they did that. If they didn't do that, like I said a few minutes ago, you can't get into this option anymore. Some other changes that happened, and part of this is dependent upon where you are in the state, because if you reside and operate within the South Coast Air Quality Management District, that's Los Angeles Basin, or the San Joaquin Valley Air Pollution Control District, that's the Central Valley of the state of California, and you have a project that's going to have more than 2,500 total horsepower of diesel portable engines, there are special notification requirements that you have to meet unless you're using nothing but tier 4 final engines. If you have an emergency like we're going through right now with some of these fires, it is legal to bring non or phased out engines into the state of California for operation, tier 0s and tier 1s, for example, but they are only allowed to be operational for a year. Once the year passes, you can get a citation for having those in the state of California. And if you think the year is a long time, I want you to think about the Paradise situation. It doesn't seem possible to me, but we're 2 years from when that actually happened. And we had a large number of older generators that were brought into that area to help the clean up and help the population get back on their feet. And those are no longer legal, and they haven't been for some time. If you have a low use engine, you will be required to submit your hours, your usage, when you renew your registration with ARB. One of the things that ARB said they would do for local districts is to track the low use engines. And speaking of low use, that number that is allowed increased to 200 hours per year. It used to be 100 hours per year. And there is a way to keep older engines that are being phased out as long as you do a notification soon enough. So the tier 1s were phased out at the beginning of this year, but if you had a tier 1 and you wanted to drop it into the low use category, you could have applied for the option to do that as long as the application was submitted prior to June 30th, which is 6 months before the date that it was phased out. And you could still be using that under low use. That is true of any diesel engine that is being phased out. If you have a tier 2, when it gets phased out, as long as you notify us via application 6 months prior to the phase out date, that can be converted to a low use option. One of the bigger things that happens with this regulation, this ATCM, is that any engine that's being phased out cannot be sold in California once it has been phased out. So keep track of that. That's something that we've been dealing with some of the auctioneers and auction sites because they sell some older engines sometimes. As far as enforcement is concerned, as I said earlier, it's the local district that handles all the enforcement. The CARB staff will handle fleet averaging for large fleets, but any other portable enforcement, whether it be engines or equipment units, is handled at the local district. Even when you do a renewal, one of the things that happens when you get a new registration from ARB, as well as every time it gets renewed, there has to be what's called an arranged inspection with the local district where that unit is basically housed. That is called your home district. That is the district where that unit is supposed to spend most of its time. Well, that doesn't mean it's there all the time. In fact, the whole idea of a portable engine or a portable equipment unit is that it moves around. But if you have one of these things and you have to categorize where it is most likely going to be or where it spends most of its time, that is where your home district is. And that has to be on the registration. Every 3 years, your home district has to come out. They have to send an inspector out to do an inspection of the unit. One thing that I will suggest to you is to make sure that when you do these arranged inspections, ensure that the units are available for the inspector on the day that you've scheduled the inspection. The last thing you want to do is have an inspector be scheduled to come out and have none or very few of the units, or maybe not all of the units that inspector is supposed to be looking at, not in the place where they're supposed to be for that inspection. All you're going to do there is tick off one of the local district inspectors, and you're likely to have more enforcement than you did before. Home districts can be changed if you have a situation where you're moving the unit to a different area of the state and you want to change the home district. You can do that when you renew the permit. If it's in the middle of a permit time frame, in the middle of the 3 years, then only the local district can request that change, and it's the local district that you're moving into that would be the one that would request that change. And that is the information I have on the portable equipment registration program and the portable diesel ATCM. There is a lot more information than this on PERP. In fact, of all the topics we talked about this afternoon, this one probably has the most information that I had to leave out just for time's sake. We have another course, it's called CR 101. It's a full day of training just on portable, and I would encourage anybody that has to deal with this to take that class. And I believe there's a recorded version of that somewhere floating around, linked on one of our web pages. Anyway, Katie, do we have any questions right now?
We do. That was great timing. Okay, so this is a public nonprofit. Would they be considered public agency?
Public nonprofit.
Yeah, what organization do you work for, Martin?
Does that mean it's owned by a city or a county?
American Red Cross.
Who owns American Red Cross? I don't even know.
I don't know either. Public nonprofit, apparently. I don't think that would qualify though, so that would still be private.
Yeah, so I'm inclined to go that direction as well, but I don't know for sure. I would have to check. I would want to know who the actual owners of it are.
Yeah, that one's a little of a gray area, but he has 2 buses with 2004 engines. And I think they have filters is what it sounds like, and reporting every year. So he's asking if they need to retire at the end of the year. We don't know the GVWR yet.
Okay, well, 04 engines, if they're in the light class, would be retired at the end of this year, drop down to low use under the truck and bus.
Mm-hmm.
Even with filters, if they have filters and we actually consider him to be a public agency, which I'm not sure how we do that, but then he's okay. But we have to make that determination. So what's his name again?
Martin.
Martin, if you want to send either Katie or I an email, we'll try and determine that for you. My gut tells me that nonprofits are not considered public agencies, but I need to know the ownership, frankly.
I'll send you, Randy, I'm going to send him your email just because I'm out of the office tomorrow, so I don't want it to not get attended to.
Sounds cool. Any other questions?
Yes. Okay, so portable equipment question. What is needed to prove that the engine has been sold? And how long do you need to retain that information?
That's one thing I didn't talk about on the portable side of things. The record retention is 5 years. So you would need to keep a bill of sale for that period of time to prove that you actually sold it. And because if it's a diesel engine, we're requiring it to be sent out of state, we would want to have documentation that whoever you sold it to was going to take it out of state. I'm going to turn the timer on just so everybody in the audience knows this. You got 10 minutes on the clock right now because we're at 3:30. When this timer is done, I'll be shutting the webinar down, but we'll try and answer all the questions we have in that period of time.
Okay, next question is, what if you have a portable engine that's no longer being used, but it's still on site?
Well, it would depend on a couple things. If it's not registered or if it's not registered through CARB in our registration program, or it doesn't have a district permit and it's not an engine that can have either one of those things, you pretty much are going to have to get rid of that thing because there's no way to get it registered, or I don't believe any district is going to permit something like that. So it's something that you probably want to think about getting rid of, and before some district inspector actually comes in and sees it operating there. Or even if you're not operating it, they can still write you a citation for it just being there.
Yeah, it's based on ability to be used. So even if it has the potential to be switched on, then it's considered still in use.
If you're selling a device or getting ready to get rid of it, what I would suggest that you do is disable it in some way, either with a lockout device or removing the fuel tank or something, to get past what Katie was just saying, because at that point it no longer has the potential to run.
Yeah, normally you have to do a few of those things. So if you lock it out and then drain the fuel and you know, you have to disable it a few different ways. That's not just like, okay, then we put more diesel in it and now it's able to be turned back on again, then it's still a little more questionable. But if you take a couple steps to make sure that it's not able to just be turned on, then that's also helpful.
Yeah, the more you can do to make it look like it's not being used, the better off you are.
Okay, and then, so Martin gave me his trucker's ID and I did look it up. So it looks like you're reported as a normal fleet. I don't think it's a public agency. And then the two vehicles in question are over 26,000 pounds.
So they're already, well, they said it was 2004 engines.
Yeah. So
Those are already, I'd have to look at the schedule, but I think you're
it's
already.
2021.
Is it 05 and older that's 2021?
Honestly, I have to look at the schedule every time.
Yeah. Well, Martin, if that's the case, then you're going to want to either drop those into low use in January or retire them.
Okay, and then our next question. Okay, so this person has a fleet of transportable engines that only operate in one district. Is there any advantage to registering these with PERP? Yes. So
Absolutely.
it's the fees are a little bit cheaper with PERP. And then you only have to renew every 3 years. And then the best part is you also only have to get inspected every renewal. So you're not having an annual inspection, which is what's required if you have a district permit. You're inspected less often. The one thing I will say with that is if your portable engines are used specifically at certain sites, like if you only have 2 sites, but you have 5 portable engines that you rotate between those 2 sites, they're not really portable engines because they're returning to the same spot. So just verify that they're actually portable before you go that route. But I would say if you're eligible to use the PERP program versus the local district program, then yeah, go for PERP. Next question, is there any extension to this year's phase out schedule due to COVID-19? I haven't heard anything like that.
No, our agency hasn't gone down that avenue with any of the regulations.
Mm-mm.
Whether you think it's right or wrong, they have not paused.
We do have, like, if there's a manufacturer delay, there's already things in place for that. Like if you're in contract to get a new vehicle and it's not going to be delivered for a certain amount of time, I could see, like, we already have something in place for that. But I could see that applying to this situation just because there are going to be manufacturer delays.
Yeah.
And so for the heavy duty trucks, it is January 1st, 2021,
Okay.
just to circle back to that. Martin, though, or should I'll send you the truckers information too, and you can send them an email just to see if you guys would qualify as a public agency. I don't know for sure that that would help you, but I always feel like it's worth asking, so.
Yeah.
Because for public agencies, you don't have to upgrade the engine.
Right. You just have to filter them.
Yes.
At least until ACT.
Right. And then just as an FYI, we did have multiple people asking about the public agency regulation. We do offer classes on that. If you go to the truck stop page and click training, it'll be under this, I think it's school and public agency.
Right.
I sent it in the question dialog box too, the link to that training page if anyone's interested. We do have that coming up.
Yeah, it's MS 522 for public agencies and MS 523 for schools. And there's a lot of crossover between those two.
Yeah, but it does talk about the on-road vehicles specific to the public agencies.
Right.
And we're offering that September 3rd.
That's not that far away.
Nope. And then for the 523, we have that October 1st. So if you're a school, October 1st, and if you're public agency, September 3rd. Okay, so what about engines that create vacuum that are portable? So I think you're talking about like a ditch witch sort of situation. So it's not so much about the engine function, I guess, in terms of like what it powers, but it's about if it's propulsion or not. So if it's not a propulsion engine, if it's an engine on a trailer that you pull around with a vehicle and it's over 50 horsepower, then it would be portable. And then for propulsion engines, if it provides propulsion and it's over 25 horsepower, then it's off-road. Okay, I think we're all caught up on the questions and it looks like the timer is up. If anyone has any additional questions, again, feel free to email Randy or myself or use any of those contact resources that we gave you throughout the presentation. But otherwise, we're going to end it for today and everyone have a good day.
All right. We'll talk to you guys later.